The Honorable, the Judges of the United States Court of Appeals for the Fourth Circuit. Oyez, 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 all persons having any manner or form of business before the Honorable, the United States Court of Appeals for the Fourth Circuit are admonished to draw nigh and give their attention, for the court is now sitting. God save the United States and this honorable court.
You may be seated. Ms. Hagan. You're ready.
Good morning, Your Honors. May it please the Court, Amelia Dagan, pro bono counsel for petitioner, Mr. Melvin Funes-Ortiz. In this case, the IJ properly granted Mr. Funes deferral under the Convention Against Torture, where Mr. Funes is one of 6 brothers, all of whom have been threatened, tortured, shot, or killed by Los Chorizos. Specifically, the IJ found that a Honduran military police officer accompanied and stated full support for Los Chorizos at multiple instances of torture. She found that this all occurred in a country where law enforcement and the gangs are, quote, essentially the same. The board erroneously reversed the IJ's findings on internal relocation and acquiescence by applying the wrong legal standard, which infected all subsequent review of the IJ's decision. On acquiescence, the board engaged in its own fact-finding, distorted the record, and opened the door to an unworkable framework for acquiescence. On internal relocation, the board ignored significant, unrebutted evidence regarding Mr. Funes' unsuccessful past relocation and failed to substantively analyze the possibility of future relocation. We are asking this court to remand this case for the board to correct their legal errors.
Counsel, can I ask you about just what you said on relocation? Your view is that your client did not successfully relocate?
The Honorable, the Judges of the United
Yes, Your Honor.
States Court of
As the
Appeals
IJ found, he had
for the
not
Fourth
successfully
Circuit.
relocated in the past due to the fact that he had been
Oyez,
hunted while he
oyez,
was in
oyez.
San Pedro
All
Sula
persons having
and
any
then
manner or
continued to be
form of
pursued
business
even after he
before
fled
the Honorable
Honduras.
United
But then the
States
IJ
Court of
mostly
Appeals
focused,
for the
then
Fourth
made the
Circuit are
ultimate
admonished to
substantive
draw nigh
Can I
finding.
go
and
back
give
to
their
the past
attention, because the court
relocation
is
though?
now sitting.
And I don't want
God
to seem
save the
flip
United
about this
States and
at
this honorable
all.
court.
I understand that
Thank you.
the
Please
gang
be
was
seated.
seeking your client, but they didn't find him. I mean, he was safe for 6 years with no
All right,
contact
we'll
with the gang. So how is that not a
begin
successful
with our first case.
relocation?
He was
Mr.
not
Newton.
receiving direct communication from the gang, Your Honor. However, we analyze internal relocation in the CAT context. But the established asylum framework, I think, is very instructive here. In ULA, this court has stated that the applicant should not have to live in hiding. In Ortez Cruz, applicants should be able to relocate and be safe from the ones who would harm them for the rest of their lives.
Doesn't the record
Can you
show
speak
that
up a little for me?
his real
sure.
problem occurred
The only
when
issues
he
that are in
went back
dispute
home to see his
are whether
parents?
there were exigent
In other words, he had
circumstances,
been in
an
San
issue
Pedro
not
Sula
addressed by the
for
district court,
6
and
years,
the
and then
issue that the
decided
district
to go
court
home.
did address,
Wasn't that
whether
when
there is a
the
remedy that
problem
still
started?
exists after
No, Your Honor,
Hudson
his
versus
visit home
Michigan
to La Laguna was
with
in
respect to
2012, so
3109.
he had briefly left, returned that same
The
year.
exigent
That is when he was
circumstances
shot,
issue is not
and the
properly
gang
before this
followed him
court,
to
so I'm going to address
Tegucigalpa,
the
which is hours
issue
from
that
his
Right, but-
hometown.
did
But didn't
deal
he
with, which
then
is whether the remedy still exists.
relocate
Why do
for
you say
6
that the
years
exigent
and
circumstances
then
is
went
not
home?
After
properly
that,
before the court?
that
Because
time
you
in
can
San Pedro
affirm
Sula,
on
no, he
the
did not
district
return home,
court
Your
on
Honor. He fled directly to the
any
U.S.
ground.
Well,
After he
as
picked up
the
his son
other
in
circuits have held, the Fifth
2017 when
Circuit,
he
and I
was
believe the
received,
10th Circuit,
2017,
this
2018,
is
when
a
he received news that his
fact-bound
brother had been
issue.
almost
Well, then
killed.
when was he attacked
Factual
in
findings, something that a
Tegucigalpa?
court of appeals
You'll help me with that
would not do.
timeline.
Oh, that was also in
District court
2012,
made
Your
no
Honor.
such
That was
factual findings,
shortly
because
after the
court
shooting in his
simply, as a
hometown. The
matter
gang
of
followed him
law,
to Tegucigalpa,
found there is
beat
no
him to the point of
remedy for a
unconsciousness,
suppression
and to the point where he was
remedy for a
hospitalized and left with
statutory
permanent
knock-and-announce
scars. And
violation.
then
So I would ask the
then he
court to
was able
address
to
the legal
travel on
issue
home after his
and then
hospitalization.
Let me
remand
ask you
for
then
the
a
district
question.
court to make
Seems
fact
to me it's
findings
one of
about
two
exigent
things that you're
circumstances.
primarily
Regarding the legal
Are you
issue, the
primarily
government takes the
arguing
position
that the BIA
Supreme
did
Court's
not
Fourth Amendment
discuss
ruling
future
in
relocation
Hudson in
as a separate
2005
element,
overruled effectively
but
the
merely
Supreme
relied
Court's
on the
decision in
past
Miller?
relocation?
Now, the government doesn't
And
mention
so
this
you're
court's
saying that
decision in Mullen, which
procedurally
I
they
cited
didn't do
twice in
what
my
they
opening
needed to
brief.
do?
In Mullen,
Yes, Your Honor.
this court
Or are
held
you arguing in
squarely
front of us
that the
that
suppression of
the record
evidence is
shows
required
an
when there is a
inability to
violation
relocate?
of 3109?
Both, Your Honor. The internal relocation aspect of this claim.
The reason the
the-
Supreme
which
Court's
of
decision
those
in
are you
Hudson does
Are
not
you arguing
overrule
both?
either the prior
Both, Your
panel's
Honor.
decision,
In this case, the
published
record does
binding
support the
panel
IJ's
decision
finding that
in
she had
Mullen,
made
or the
that he had not
Supreme
been able
Court's
to relocate
decision
in the
in Miller,
past, and the
is
IJ
that the
ignored,
Miller decision
apologies,
and
the
the Mullen
board
decision
ignored
are based
significant and
upon the
unrebutted evidence
supervisory
regarding his,
authority
that ability.
of the
They didn't
federal
mention the
courts,
hunt
not the Fourth
for
Amendment.
Mr.
There's
Funes while he
three
was in San Pedro Sula. They didn't
rationales
mention
for
anything of what had
applying the
happened after he fled Honduras.
As
But
I
then,
understand it,
to
there are
your
three
Honor's second
different
point, the
circuits
board improperly focused their analysis
that have
only
held
on the
that,
past without substantively analyzing the
suppression
possibility of
is,
future internal relocation,
under
and that's what's
Hudson, that
required under the
suppression is
regulations.
not a,
The IJ had correctly balanced all the
remedy
factors in her
for a
analysis. She found that Mr. Funes had
3109
not relocated in the past, but that is
violation.
ultimately relevant for cat protection.
so
He
we
could not
would be,
relocate in the future. The
going
board committed
against
legal
three
error by really
circuits.
only
Those
discussing the
circuits are wrong.
past. They
Sutherland,
All
concluded
three
that
of
he
them
had
are wrong.
relocated in the past
And
on
for
the
this reason,
basis of only
in
three
Sutherland-
cherry-picked
That doesn't
facts, and that is a factual
That
conclusion
doesn't
not
speak
supported by
very
substantial
highly of our
evidence.
good
But then
colleagues
the
across
regulations
the
also
country
don't seem
to
to
say,
support the
well,
board's
Judge,
implied
as you
finding
know, their circuit
that
splits all
past
the
relocation
time.
is somehow
The
dispositive
the
of the
Sutherland
ultimate
decision,
question,
which the
which
other
is
two
whether
rely
Mr. Funes
upon,
could safely
is wrong.
relocate in the
It's
future
wrong
in a
because
country
it
that this court
equated
has
the
noted in the past is
purposes
smaller than the
of
state
the
of North
Fourth Amendment
Carolina.
exclusionary
And
rule, I should say
relevant,
purpose,
right? The ability
which is
to relocate
deterrence.
safely in the
That's the
past.
sole purpose for the Fourth Amendment exclusionary
Is it that
rule.
the board
There are
erred
three
by
different
considering that
purposes
at all,
behind
or
the
that the
supervisory
board
authority rule.
by
Deterrence is
stopping its
just one.
consideration
There's
there?
also judicial
The error,
integrity.
it wasn't stopping there, Your Honor.
and the
Undoubtedly,
Supreme
past
Court has
relocation
said, in
is
addition to those
one of
two,
the many factors
even
that the
if
fact finder
the
is supposed to consider in this
Constitution doesn't require a
holistic
remedy,
analysis of whether
the
someone will
supervisory
be tortured
authority
in the future,
rule can
but it's only
provide
one
the remedy.
subpart. This
So
court has never
Hudson-
found that
I mean,
past relocation is somehow
suppose you'd have a
dispositive or
tort
even
remedy.
presumptive of the
We're not
ability to
saying
relocate
you
in the
without a
future.
remedy.
The government
no,
cited two
we're not
cases in
talking
their
about-
briefing
excuse me, you can bring
for
a
this proposition that a
1983
previous
case if that's what you
relocation
wanna do.
undermines a finding
Well,
of future torture
Your
in
Honor,
some
this
way.
is not
However,
about
both were
remedies in the
unpublished.
civil
One was from the Eighth
context. This is
Circuit,
about
and the one from
remedies
this
in the
circuit,
criminal
Romero
context.
Donato,
And the
doesn't
Supreme
contain
Court's
any of that
decision in
language.
Mullen, I'm sorry, this Court's
that was
decision
cited
in
in the
Mullen.
briefing
and
No,
the
for
whether
that
it's
premise.
statutory or
So
What if the
constitutional.
board had said,
Get the
we now
idea that the
proceed to
Supreme Court
discuss
is
the
not very
issue of
fond
future
of the,
relocation?
of the
And the
exclusionary rule.
record shows a 6-year
It was an,
period in which he was able
it was an
to
implied
relocate
remedy
within the
to
country.
begin with. I
We consider
recognize
this
that
evidence of past
it has
relocation
its
to be
value
so
and it has its
extensive in
merits
this case
and
to solve the
judicial
question of
integrity
ability to
is part of
relocate
that,
in the
but
future. What would be your argument then?
That case is not before us,
the,
Your Honor, but insofar as they are saying
I'm
that
just
the
afraid
past
that
necessarily dictates the
if we,
future, I think that defies logic.
Go against
no,
three
what I'm
other
saying is, what
circuits
if they had said
and buck up
that
against the Supreme Court's
the extent
expressed
of
displeasure
time
with
that
the
passed
exclusionary
in which he
rule in
was able to
Hudson
safely relocate
that we would
is
be asking
compelling,
for trouble.
And we
Well, Your Honor,
feel
I think you're bound by Miller
that
and
this
you're
is
bound by Mullen.
sufficient
And if the en banc court or the
answer the
Supreme
question
Court
of
wants to
future
get involved
relocation.
because of
Miller-
that,
would you,
Yeah,
what would be
even
your
going-
argument then?
Putting aside.
case, Your Honor,
some of the issues Judge Wilkinson's talked
Internal
about.
relocation is a factual finding,
read
and thus
Miller,
the IJ's
it's
finding is
really
due deference by the board.
referring to
The
3109
phrasing that Your Honor just used
in
indicated to me that the
describing
board
the kind of
was doing its
common
own
law
weighing,
principles
making its own
that
factual finding of what
are
substitutes internal
background,
relocation or not, and without
for
giving
this
deference to
whole
the fact that the
knock and
IJ
announce
already found
concept.
that he had not
It doesn't
relocated in the
seem
past and
to
could not in the
really
future,
articulate
based on the whole record, including
3109
the
as
facts that the board was completely
separate
silent on.
See, this is getting back to my point of
ground,
the remedy that you're seeking
apart
here,
from the
and whether your
constitutional
argument
ground.
is primarily
It seems like it's
procedural. In other
the
words, the
discussion
board
there
didn't
more
conduct
is
the
in
correct
general
analysis.
background.
You're
and
asking us
then
to send
Hudson
it back
talks about
for
that
a
same
correct
common law
analysis.
background.
well, if I could, Your Honor,
could
there
you
are two
explain
problems
more the
with that
remedy that you're
hypothesis.
seeking?
Number one,
And
the Supreme
what
Court in
you're
Miller
asking
did not
us to
just
tell the
hold
board
there is a
on
common law
remand
knock and
if we
announce
were to
requirement.
agree
It held
with
there
you.
is a suppression
Yes, Your Honor, we are
remedy
asking for
that
remand in this case
violation.
due to the legal
And
error
in
present from the board
Sanchez-Llamas,
in terms
after
of
Hudson
ignoring
versus
evidence
Michigan,
and
the
not
Supreme
substantively
Court
analyzing
explicitly
everything that the
referred to Miller
regulations
as a
require on internal
supervisory
relocation.
authority
On
rule.
acquiescence, we are also
That is
asking for
binding
remand,
on
given
the
that the
lower
board committed
courts
3
until
legal
the
errors of its own
Supreme
in that
Court
area.
says otherwise.
The board
Very
failed
clearly
to apply
established.
clear
The
error review
Rodriguez
in
case
reversing the
said-
IJ's
What do we do
uncontested
with the Supreme
finding,
Court's,
even conceded by
I
DHS,
think it's
that
a
the uniformed
Ramsey
man who
and Bank
accompanied Los
decisions,
Chirizos was who
where
he
the
said he
Supreme
was,
Court
a
seemed to
uniform,
be
a government
treating
official,
Fourth
and he was
Amendment,
acting under color of law. The board
violations
engaged in
and
pure speculation on this fact when it found that this
3109
man was actually
violations in
simply a
the
gang
same
member
way.
who possessed a military
For
uniform.
the
They had
substantive,
murdered
Under this court's case law,
for the
Orellana,
substantive
Barajón,
right,
and many
there is
others,
absolutely
the board is
no
not at liberty to
discussion
distort or disregard
concerning
important elements
is there
of an
a
applicant's
difference in
claim.
remedy.
The board is
I'm going
also
to go
not
back to
allowed
what
to
I
engage in
started
its own
with. There are
fact-finding,
three
but
reasons
owes
for
the IJ
supervisory
deference.
authority rules.
Here, the IJ's findings
That's
were not
clearly
clearly
established.
erroneous, but
The
were based
Supreme
off of
Court
Mr.
says that.
Fuñez's credible
They only
testimony
addressed
and his family's
one reason in
declarations.
abandoning
Even
the
DHS conceded
exclusionary
in their
rule
brief
under the
to the
Fourth
board
Amendment in
that this
Hudson.
man was indeed a member of the
Therefore,
Honduran
there is
military
direct
police.
application
This
of
officer
Miller and
accompanied Los
Mullen.
Chirisos on
Mullen,
two
by the
separate
way,
occasions
specifically
when they shot,
cites
threatened, and
3109
attempted
in
to drown
discussing
Mr.
Miller.
Fuñez's
That
relatives
binds
to
this
get his
panel.
address.
I don't
The
think this
officer
panel has
clearly
the
stated
authority
that
to
Los
do
Chirisos
anything
had
other
the
than
military
apply
police's
Miller and
full
Mullen.
support
If
in
this
their
goes on
quest to
bond,
murder the
we can
Fuñez
take those
family.
arguments to the
By
next
failing
step.
to defer to the
But
IJ's
stare
findings and
decisis
engaging in
for what?
important permissible fact-finding, the board committed legal error on that matter.
Can I ask you
Let's
a
just
question
say
about the IJ's
suppression
findings
is
on
not
that?
the remedy.
So the IJ
That evidence comes in, what
lists
case
out
do you
all the
have?
factors you're
Oh, if
supposed to
suppression is
consider
not the
in
remedy,
deciding
I'm-
whether someone is
I have no
acting under color
argument.
of law.
This is all about the
And
remedy.
then doesn't
This is
apply
not
any
about
of
the
them.
right. The government
Lists the
acknowledges,
factors
even
and
under
then says,
3109, there is a
under
right to
circumstances.
have
No, but I
office.
mean, I thought Hudson said
So
the
the main
suppression
factor is
remedy
supposed to be, I think,
has
that,
cost
the
and that
person's
it
official
keeps
status is
truthful
what enables
information
them
away
to sort of carry out this
from the
torturous
jury. And
conduct.
they're sitting up there
What's the
and
best
they're
evidence of
saying,
that here, that,
we've got to
that this person
balance
assumed
the
it's
the value of
say,
judicial integrity on the one hand, but we've got to
that it
take
is
into
by virtue of
account
his status
the
that
fact that it's the jury's job to
because the
decide
record
whether
is-
these people are
it's a
culpable
dreadful
or
record.
not, and you don't want to keep the
Sounds like
truth
members
from
can
them.
miss whether or
Judge,
not
you're
it
mistaken.
was
The Supreme Court did not consider judicial integrity in Hudson.
In this case, Your Honor, the IJ did list all the factors and noted, for example, that he was in uniform, he threatened retaliation through official channels.
Solely
Those are all
about
part of
deterrence.
matter of
There are two
JGR's
other
holistic
reasons that
focus.
are still out there for the supervisory rule in Miller that have not been abandoned by the
In this case, Your
Supreme
Honor,
Court.
he was saying that there was the ability for Los
I'm
Chirisos
not
to
sure we're
act and
coming
do whatever
to
they wanted, and that the
complete
military
agreement on this
military
point.
police would
But
support
I'd
them.
like to,
That is through the official channel of the military police
move
supporting
just a
this
minute
violent
to the
activity.
exigent
And in that case,
circumstances
that is
question.
So
what
you
happened.
understand the
Yes, Your
statement to be a
and
threat
you're
of
right that the
retaliation
district
will
court
not
didn't
with the
rule on
military
that,
police.
but
If you try to do anything about this,
on
we
the
will
other hand,
be back.
Yes, Your Honor.
How
In
could they
under
not?
acquiescence, the second legal error
How
was that the
could they-
board erred by distorting the
Hold on a
record
minute
regarding
now.
Mr.
I
Fuñez's
know you-
engagement with the
I
Honduran
appreciate
police
you
and their
eagerness to
acquiescence to his and his
argue the
family's
case,
harm.
but
The board
how could
stated that
there
Mr.
not be
Fuñez, quote,
exigent
never followed up
circumstances
after
here?
reporting the
Because
gang
I
to the
think
police, but this ignored Mr. Fuñez's credible
affidavit,
testimony that while he recovered from a
from
gunshot
the
wound, he sent his mom on his behalf, as the
warrant
police had told him he could do.
showed
The board and the
drugs
IJ
and
both acknowledged
firearms
that
in
the police went to the
in
shooter's
the
house
That's
once.
what the affidavit
However, the board
was-
disregarded the
for
IJ's later
warrant was
finding
claiming.
that the police took no
And
further action and that Los Chirisos
in
continued to act
addition,
with impunity,
the
actually
officers
intensifying
had
their harm of the
reason to
Fuñez family
believe
after Mr.
that
Fuñez
these
reported the shooting to
particular
the police.
defendants had
But ultimately,
murdered
Mr. Fuñez need not prove
their
that the entire
supplier,
Honduran
an
government would
individual by
acquiesce to
the
Los
name of
Chirisos. Such a
Mr.
Herculean
Smothers.
task would violate
Now,
the clear text of the
if these-
regulations that require only
if,
that torture be inflicted by
If
or with
these aren't
the
exigent
acquiescence of a public
circumstances, I have
official
a hard
or
time
another
figuring
person
what
acting in
would
official
be
capacity.
exigent
And the
circumstances.
IJ found more than this
Judge,
here.
it's not
The
the
IJ
Court of
considered evidence of
Appeals'
Mr. Fuñez's
place
particularized
to make
risk,
fact
and she
findings.
also
An
discussed the
affidavit
broader
has
context
been
of
filed
evidence
by
that
an officer,
Honduran
but
authorities
that's not
direct gang
tantamount to
violence
a
are
finding.
involved,
So aside
and that
from
the gangs
that
have infiltrated
issue, which
Honduran
is
law
fair
enforcement
as
to
a
the degree
general
that they
principle,
are,
you have
quote,
an
essentially the
argument
same.
that it's under
The board
these
conversely
facts,
doesn't
under
accurately
this
discuss this
record,
evidence,
that this would
and
not
indeed
be
seems to
exigent
chastise the
Yes,
IJ
2
for
months
analyzing both
passed.
of these
2
things.
full months
Mr. Fuñez's
passed
particularized
between
risk and
the
country conditions
alleged
evidence,
murder
even though all of that is
and
required
the
under the
execution
regulations.
of the search warrant.
Finally,
It
the
was
board erred
also
in basing its
the very
reversal of the
early hours
IJ's
of the
acquiescence
morning when
finding
people would
largely
be
on the
sleeping.
fact that the
I think
police
this is an
responded
argument
at least
to be
once
made
to Los
to the
Chirisos'
district
crimes.
court. This is not
In attempting
something
to
the
defend
Court
this
of Appeals should
decision, the
decide.
government
If I
goes
very briefly
a step
could go
further
back to
and argues that
the
there can be
judicial
no
integrity
acquiescence
issue.
if a government government took any steps whatsoever to curb non-governmental violence, or if the torturer has any fear of any authorities at any time.
This
is simply unworkable.
Abandons the
If
suppression
any government
remedy in
official
the
took
Fourth
even the
Amendment
most flimsy
context,
or
one of the
disingenuous
cases in
step
which
towards
the
stopping
modern
gang
Supreme
violence,
Court has made
then
it
under the
crystal
government's
clear
test,
judicial
no one from that
integrity is
entire country
irrelevant
could
under the
qualify
Fourth
for cat
Amendment, but
relief.
it is very
This
relevant
court has already
for
rejected that
purposes
idea in
of
Portillo-Flores,
the
emphasizing that the agency
supervisory
must
authority
perform
remedy.
a proper
And
analysis of the
therefore,
applicant's
Hudson
specific
does
circumstances,
not have direct
regardless
application.
of
Miller,
governmental,
and as interpreted in
general
Mullen,
governmental
have direct
efforts to combat
application.
violence
Under
and corruption.
Rodriguez, a
This was
federal
also
court of
rejected in
appeals
Diaz de
has no
Gomez and Ponce
authority to
Flores.
overrule
And this is
binding
consistent
Supreme
with the
Court, that is
first,
directly
Second,
applicable. That is for the
Third,
discretion of the
Seventh, and Ninth Circuits,
Supreme Court.
all of whom have rejected the extreme position that mere government efforts preclude a finding of acquiescence.
Yes.
For example, in the First Circuit, in HH,
Is
they
your request
remanded
for
with
relief
noting
under
skepticism that any
2106?
record evidence of efforts taken by the foreign government to prevent torture,
So
no
there
matter
was
how
no
minimal,
citation
would be
to
necessary
2106
to
in your-
preclude a finding of
in your opening
acquiescence.
brief.
The Ninth Circuit has repeated this
I
multiple
apologize
times
for that, Your Honor.
in
It is the
Barajas
Seventh
Romero
Circuit's
and
position. I cite
Madrigal,
the
Claiborne
noting that
case.
general efforts to
cite
curb
that.
gang violence are not
And-
enough on their
and
own to defeat a
what would
finding of
prevent you from
acquiescence.
Counsel,
seeking
can
a
I go
sentencing
back to,
reduction under
Judge Keenan's question?
3582?
So it
Nothing, but
sounds
he
like
would
you're
not be
making an
represented by
argument
counsel
that
at the
the
time. He is
DIA's
represented by counsel
finding
now
here
and
is
would be
not
represented
supported
by
by
counsel if the
substantial
court
evidence.
remands.
But that is not your
That's my
argument.
main
You don't
argument.
want us to say that.
And do you have an
want us to
argument on the
send it
timing
back
of
until
raising this issue?
the BIA what?
I'm sorry.
In this case, Your Honor,
In terms
substantial
of the
evidence is
sentencing
not the
guidelines
relevant
issue,
standard. These were legal
I guess I'd
errors,
just like to hear your
overlooking
argument.
evidence
Well, it
and
was not
being
promulgated
silent
by
on
the-
that,
by the
engaging in their own
Sentencing Commission until months
fact-finding.
after
I don't
And
understand when you,
So it was not.
Although it was known at sentencing.
it seems
that
like a
was going to
very
go into
fine
effect.
line.
Well,
between
Congress
saying
always
the
has the
BIA
veto power
made a
up until
legal
October
error in
31st of
overlooking
the year
evidence.
that the amendment is
And
promulgated.
there's not
A court would
substantial
lack
evidence to
authority
support
to
what the-
apply
So are
a
you
sentencing
conceding there
guideline
is
before it
substantial
goes into
evidence to
effect on
support
November
what the
1st under
BIA
the
did
Sentencing
here? It's
Reform
just
Act
that the BIA
1984.
made some procedural errors.
Certainly, a
along the
lawyer
way.
could ask
Is
the
that your
court to
position?
defer
Your Honor, I see I'm over time. May I
consideration to
answer the
sentencing.
Yes, you
but
may.
in my
Thank you.
experience, a lot of courts.
No, Your
once
Honor,
you're really
we
close to
believe that
November
here there
1st,
are
they
legal
don't.
errors
But
that can be
doesn't
reviewed
stop
de novo by
somebody
this
from
court.
raising it
However,
after it goes
even if
into
this
effect.
court
The
were
effective date
to
is November 1st.
find that there
After
was no legal
sentencing,
error,
long
we do
after
not believe
sentencing.
substantial evidence
Thank you.
supports this decision, given
you.
that, for example, on the acquiescence finding, there was nothing in the record at all to
let's see,
suggest
I
that this
think you're
was
not up
not
quite yet,
a military
Mr.
police
Duke.
officer,
Mr.
as even
Young.
DHS
Well, if that's
conceded.
true, why are you arguing
No
about
problem.
a bunch of procedural errors? I'm just not really understanding, I don't mean to, argue
morning,
your
may it please
case
the
however you want to
Court.
argue your case, but if
I'm
your
here to argue that
fallback
the evidence at
argument
trial was
is
insufficient to
there's no
support a verdict
substantial
of guilty
evidence
as
in
to
the
count
record to
6, which was
support
put
what
to
the
Mr.
BIA
Tayon
did here, I
Williams.
guess I'm not really understanding
Tayon Williams
why
did
that's
not
your
constructively
main
possess
argument, because
drugs
if we
found
agreed
in
with you
Scott
on
Williams'
that,
home in
your
June
client
of
would
2018.
prevail.
The prosecution
more than
theory at
just a
trial was that
remand
the
to
drugs
the BIA.
belonged to
So
the alleged supplier, Mr. Smothers.
I don't want to keep
However,
you
the
over your
jury
time, but if you
acquitted
can just
Mr.
sort of
Williams, Mr.
explain that
Tayon
for me, that
Williams
would be really
in the death
Yes,
and
Your Honor. In this case,
disappearance of
the
Mr. Smothers.
factual issues are
Tayon
very
Williams
complex,
did not
and
reside
insofar
at
as the
home,
board might have
Scott
thought
Williams'
that there
home.
was
That
some
was
need
established
for
through
further
numerous witnesses at
fact-finding
trial.
or factual
Although he did,
clarification, then they should have
visit the
remanded that to
home
the IJ, and insofar as
and
this
frequent the
court
home
does
at
not
times,
engage
he
in
did
its
not
own
reside there.
fact-finding,
And in June of
and there are
2018, he was definitely not
disputes
living
here about
there.
what the facts even
Numerous
are
witnesses,
based on the
Mr.
board's
Cox
own
and Mr.
impermissible
Diaz at
engaging in
trial,
fact-finding.
established that
Um,
Mr.
that
Tayon
is-
Williams
that is
was
the
living
argument,
in
though,
Morgantown, West Virginia.
To Your Honor's point,
during,
we do not believe
the
substantial
latter part
evidence
of this
supports
alleged
the IJ's,
conspiracy. Also,
apologies, the
the
board's
conspiracy that's
decision,
charged is,
even
the
though there
dates of
was
the
legal error
conspiracy
as well.
are October 2017 through April
All right.
2018. And the
Thank you, Mr.
drugs
Dagan.
found
Thank you, Your
in
Honor.
June of 2018 in
Mr.
Mr.
Stanton.
Scott Williams' home were not reasonably foreseeable to Tayon Williams. Although Mr. Tayon Williams was convicted of conspiracy along with his father, Scott Williams, the dates of that conspiracy are from October 2017 to April of 2018. And no witness testified at trial that any drugs were sold during the time frame that, the June 2018 time frame that the drugs were uncovered by
It's okay.
police officers in
Yes.
this case.
All right. May it please the court,
Another witness
So,
who lived in the home.
it's important for
Mr.
this
Scott
particular
Williams'
case
wife
that there's
also
no
testified that
question
Mr.
of
Tayon
what
Williams
exactly
was
the
not a
scope and
resident
standard
at
of
the home.
review is. The government's
only
brief
visited
cites three
Did he
cases
stay there
in
when
which
he was
involved
in
this
town?
exact
There
procedural
is testimony
scenario
that he did stay at the home.
And wasn't
before
his
this
birth
court, where
certificate also
the
found in the
immigration
home?
judge granted
Yes, Your
cap
Honor.
protection, the board
My argument
reversed
to
it,
that
and the
would be
court
that
engaged
Scott
in
Williams is
what
his
we consider
father,
to be the
and
proper
therefore a
standard of
parent
review.
presumably would
The
have
inquiry
some
is
effects
not
of their
whether
children, especially
this
a young
panel
man
would
such as
do
Mr.
with,
Williams, who was in his early
review the
20s,
immigration judge's
during
decision,
this time frame.
if it was reasonable,
So
like perhaps
I know
not
this court has held that you don't have to
uphold it in the
reside
first
at a
place,
place
but,
to
I mean,
construct
the inquiry is whether this panel
I think
would
the facts in this particular case
determine
point
whether
out
the
that Mr.
board's,
Williams, Mr. Tayon,
the board determined that the IJ, I'm going to assume that clear air and speculation are functional equivalents. So is that correct?
All right, go ahead.
All right.
Yeah, so,
Now, Well,
but
Mr.
to
Booth,
the
at
extent like
long last.
the immigration judge found that relocation was impossible. And by the way, the immigration judge got off to the wrong start by employing the wrong standard of review. She said that the record must compel a finding
Okay,
of
but
relocation.
let's get back, excuse me, I didn't mean to interrupt there, but
Can you speak
let's
up,
get back
please,
to.
Mr.
I'm sorry,
what
I will
seems to
make
be
the exigent
really
circumstances
one
argument
of the
Of course.
main
As
focus
I
is
briefed
that
it in the case, if you have
you
any
and your
questions, but I
opposing
would like to
counsel have been
address the
talking
suppression
about.
issue
And that's the
because that
issue of
carries over
relocation.
into other cases.
The board
And with
never
respect to that, suppression
discussed
is not a
future
remedy for a
relocation.
Section
It seems to me
3109
that what the
violation.
board did was make
The
an
Supreme Court has
implicit
held that
finding
suppression is not required for a
that
Fourth
future
Amendment
relocation,
knock-and-announce
that he
violation in
could
Hudson.
safely relocate. In other words, the
In
board never
Ramirez
actually
and in
says that in
Vance,
Well, no,
its
the board
opinion.
never actually said
What
that,
he
but-
says-
Scope of the
just a
Fourth
second.
Amendment
Of course.
What the board
in
says is the
3109 are
respondent has
virtually
safely
identical.
relocated
And if
between
that's the case,
2012 and
then
2018
suppression,
when he
there is no
decided to
suppression
leave
under the
Honduras.
Fourth Amendment, means there's
Okay?
no suppression
The board didn't-
under
the
3109
word
as
future
well.
Why does that
does
fall?
not
I mean,
appear
why-
in the
does
relocation
that,
discussion
I mean,
of
couldn't
the
it
BIA
be
in its
that the
opinion.
scope of the
So it
remedy
seems to me that
is
you
the
have to
same?
rely
I mean,
on
scope
an
of the right
implicit
is the
finding
same,
that the
but the
BIA
scope of
was
the
saying
remedy
that the
is
evidence of
different.
past relocation
As a
is
theoretical
essentially
possibility, you
very
might be right,
significant
Judge
because of
Quattlebaum,
its
but as I
duration in
emphasized in
time,
the brief,
that
every court of
equates to
appeals
the
that has
ability to
considered
safely
this
relocate
issue
in the future.
post-Hudson has held that because
Isn't that
the
pretty much
Supreme
where you're
Court has
left in
basically
terms
said
of
the Fourth Amendment and
the relocation
3109
analysis
are
of the
identical,
board?
the remedy should be
I would
identical
respectfully
as well.
submit that, to the
I know
extent you
seems
were
almost
saying is
certain
that
if
when the
presented,
board
Supreme
said
Court would
this
say
past
the same
relocation was
thing,
successful,
that we
I mean,
get-
it's a
we're
very
not supposed
easy
to really
jump to the
predict
conclusion, implicit, if you will, that
decisions.
future
We're supposed to
relocation
make
is
it on
possible. Again,
applicable
the standard
law.
is possible.
How
I
do you
mean,
deal
it's a
with
much
Mullen?
higher standard than it is for
Mullen has absolutely nothing
asylum.
to do with this case,
Yes,
and if I might,
So-
I'd like to quote from the very
I
first
hear all of that
paragraph
sort
of
of
the Mullen
as a
decision
logical
from this
matter,
court.
but it does seem
And it
that if
says, "We
that's the
reverse
jump
the
you're
judgment of the
making,
district court
in
since
this
in our
case,
view, the
from
arresting
past
officer
relocation
enacting
to future,
without a search warrant
there's sort of a gap in the
committed an
BIA's
unreasonable
reasoning
search and
because there's
seizure
new
and
evidence that
therefore
comes out
violated
after
the broad
the
mandate
petitioner
of the
arrives in
Fourth
the United
Amendment.
States, and it turns
Mullen
out
is
that
a
the gang
Fourth
actually
Amendment
could
case.
come
It
across the
can't
country
be
because they do
a
arrive at
3109
his
case
old address.
because
I
the
think
opinion
shortly
says there
after
was
he
no
leaves.
search
Now they
warrant in
have
that
found
case.
him, and
3109
whatever
deals
the,
exclusively with
limits on this
search
gang's
warrants.
geographic
Mullen
reach were
has
before
nothing
he
to do
left,
with this
They
case.
now do include
And for the
the city.
same reason, the
And so now we
decisions
know
in
more about
Miller
the
and Sava
gang's,
are not on
ability
point
to find
because
him.
they did
So
not
why
involve
doesn't the BIA
warrantless.
have to
They
address that
involved
kind of changed
warrantless entries
circumstance?
to arrest.
Well, I mean, to the
not
extent they found him,
warranted
they only
searches
found him
under
because, like,
3109.
his brother told him
Yes,
where he
courts
was.
Because they
look to
tortured his
them
brother
for
to find out
guidance.
where he was. I mean, I
But
I
those
really do
decisions
think until
present
he
no
left,
obstacle
one could say
for
the gang
this
may be
court
looking
to
for him,
hold
but they
as
can't
with
find
respect to
him.
the other
But
three courts
after
of
he
appeals
left, it turns
that
out they
suppression
could
is
find
not
him.
a remedy
So
for a
why isn't
3109
that sort of a
violation.
change in circumstances that the
If
BIA
there
would
are
have
no
to
further
address
questions on
if
that
it wanted
point,
to
I would
infer
like to
from past
address one of the
relocation
questions
that he
you
could
had,
also
Judge Berner,
relocate safely
with
in the
respect
future?
to the
Well,
2-point
petitioner also
reduction-
testified that, like, he has
to
very little
14.18
family remaining in Honduras.
In the
That's on
first
page
place, that doesn't
177.
apply
I don't
for
know
the
that that's a
following
great
reason.
fact for the
The
government. The
district
gang
court
is
judge in this
systematically
case
killing
made a
his
specific
entire
finding
family.
And I
that
think the
the
point,
weapon,
you know, that,
that
at least
was
I think
found
the
in the
point
crawl
that
space
Judge
in
Harris is
Williams's
making is
house
you have a 5-year period
stated
from
it supports an
2018
inference
when he
it's
left
connected
Honduras
in
to come to
some
this
ways as a
country,
way
and the
to
date of the
protect
BIA
that status.
opinion, which
And
is
because the district
November,
court made a
what,
finding that that
30th?
gun was connected.
2020, is it
Just-
2023?
I don't know the date, but no.
But
Yeah,
isn't
look,
the
it said
standard
has a
there,
file
counsel,
stamp November,
not
30th,
clearly
2023.
improbable?
So that's a
That is
5-year
true
period.
under 2B1.1,
And the record's
and there might be
silent,
some daylight
in
between
terms of the
that
BIA's
commentary
analysis of
and
what
the,
happened
Section
to
4C
the respondent, excuse me, to the petitioner during this 5-year period and how that might
Our
affect
case,
the ability
in our view,
to
that doesn't make a
safely
difference in this
relocate.
case.
And
Again, because the district
why
court
wouldn't that
said-
be a
Yeah, but
basis
you're-
that we
but
would
you-
have to send it back to the board?
Go ahead, let me,
because
I
again,
want
I'm
to
just
hear
saying,
what
the
you're
there's
saying.
other
district
record
court's
evidence that
finding in
suggests
this
that relocation is
case
certainly
that
indeed
the
possible.
gun that
So, I
was
mean, like,
located in
again,
the
going
crawl
back to his
space with
family,
respect
he
to
says
the
he
drug
doesn't know where his
was he
siblings
said
are,
it's
so he doesn't know how to get in touch with
connected in
them.
some
Like,
ways
he
as a
tried,
way to
the
protect that
DHS
status.
lawyer asked him,
You're saying
why don't you
satisfies
have more,
So you're saying even if the standards
letters of
might be
support from your
different,
siblings
his
who actually were
finding
present. He
was
responded, I don't know where they are.
standard
They said
for
that
the
like,
guidelines.
Mr.
page
Stanton,
210.
Under the new one, the intensity of the violence against
doesn't apply here.
him and
in
his
this case.
family
And Judge
that
Berner, you
makes
asked a
this case
question
different?
about
I mean, the BIA didn't even mention that.
106
I didn't
and
consider the fact
Seventh
that what
Circuit's decision
Judge
in
Harris
Claiborne.
brought up, the fact that
We
they
don't believe that
tortured
Claiborne
and
is
made
correct for
his
the
family
following
tell
reason.
where he was and
It
they
turns
showed up
out
at his
that
address.
for guideline
That's how
purposes,
intense It is.
The Congress has specifically
Doesn't that make
stated in
this case different than just
3553A4A,
he was tortured, he
submittal
moved in
11
6
at 1,
years, no problem?
that a
There
sentencing
was so much that they would
court has
torture
to
his
apply the
family members,
guidelines
say,
in
"Look, you
effect
tell us
at
where
sentencing.
he is." That's
And
an
if that's a
intensity that very few
specific
cases, I've been on the court
statutory
almost 24
The
years,
district
and
court does
these
not make an
immigration
error
cases,
by
this one
failing
is,
to consider a guideline
just-
that may apply.
I mean,
sometime
many
in
are
the
horrible
future.
ones, but the intensity,
And so
I
in
want
our
to
view,
find him.
2106 only applies.
And
to
and they
those that
found where
err
he is,
by
where
the
he
district
was.
court in
Yeah,
its
but for his,
Through his brother, yes.
We don't
But then the
believe that a
BIA
court
didn't
of
give any-
appeals should simply decide,
any-
that even though a district court may have
consideration of that at all.
no error
His
in
son
applying the
relocated
guidelines,
and
this
to a
court
place
should
where
reverse the district court because
nobody
of
else
what
knew
the
where he was except for
sentencing
petitioner
commission
himself.
said.
I mean, there are a lot of towns
Now, you
in
don't have to
Honduras
reach that
where
issue.
this
This
gang does not
particular
operate. I mean, petitioner argued in his opening brief that gangs are everywhere, and the immigration judge relied on that finding, relied on this, that gangs are
Why
everywhere, but
shouldn't we-
the Maras, MS-13, and the Barrios don't seem
All
to
you
care
can
about this
expect of a
guy. Los
district
Chorritos
court
is a very, very small
is that
gang
a
that's in the
district court
administrative record.
rule
I mean, so
at
yes,
sentencing
they seem.
Go
on the
ahead.
basis of the law as it exists at
It's
the
possible
time
that
of
the BIA
sentencing.
could say something
Well, that's
like that,
correct,
but
Judge
they
Wilkinson.
didn't.
That's a
They
specific
didn't say,
statutory directive
but this
from
gang
Congress.
has limited
And our
geographic
position is
reach,
when
so
you have
he'll
a
be fine in the
specific
future. They
directive
didn't say
from
any of
Congress
that. Like, these
on a
seem like they might
specific
all be
point,
good arguments for the government to
it
make in front of
governs
the
over a
BIA
more
on
general
remand, but we
statutory
can't affirm
provision. And
on
I
the ground
understand
that
that
the BIA
2106
didn't.
106 is a
Well,
very,
there was the
very
futility
general
exception
statute that
to the
allows
Chenery
courts to use a lot
Doctrine.
of
And
discretion.
with respect to Chenery, by the way, I mean, we considered filing a sure reply brief that, like, our office views Chenery as saying that, like, I mean, holdings, I mean, findings mean different things in different contexts, but that's still to its essence. I mean, and the board says, we're denying your claim because you didn't fill element A and B. Chenery prevents the government from saying, and by the way, you also, to the court, you also didn't fulfill elements C, D, and E. We do not view Chenery as limiting the government from arguing, by the way, you didn't meet A and B based on these facts as well that were not cited by the board. We do not view Chenery as limiting the government's ability to point out why the board's ruling were supported by substantial evidence, especially in this particular case. I mean, we have to be able to respond to this theory that the gangs are everywhere, therefore relocation is impossible. No, I mean, that is not the proper inquiry.
This is not a theory case.
I would note that.
This is far
Why
from a
would you
theory
be
case.
eligible for a
I know
forced
you're representing the Attorney General.
reduction if there's
but
been an
this is not a
enhancement
theory
applied
Not
under
their case. I'm just trying to
2D1.1?
explain why
No, you wouldn't be. I would
the
agree.
Chenery
That's
arguments,
our view on
we
the
just don't
merits.
agree with those
With
at all.
respect to the
But again,
procedural
all we're
question,
trying,
whether or not
with
this
respect to
court
the
should just
limited
go
reach,
ahead
small
and
gang of low to
vacate
zeros,
a
all we're trying to
proper
do is explain
sentence by
why
a district
his
court,
theory, it's
which
impossible because the
properly
gangs are
applied the
everywhere, it's
guidelines
just
in
not
effect
correct.
at the time.
So,
Simply
so
because
what?
the
Let's go on
Seventh
to
Circuit
the,
had held under 2106
issue
it had
of
this
the,
broad authority to do that. We think Claiborne
Well,
is
you have
law.
the Second and the Fifth Circuit, as I
And it seems to
understand it,
me
they
that the board was engaging in its own
declined
factual finding
to apply
when the board
4C
said
1.1
it is speculative to conclude
on
solely
direct
on the
appeal
gang
because it
members'
would
possession of
undermine the
police
finality of
military
sentencing.
uniform.
Well, that is
That
correct,
this
Judge
individual
Wilkinson.
was
I
a
said
member
we
of the police
totally
acting
agree with
under
those
color
decisions. I
of law.
believe there is an
Well,
unpublished
the
decision
board seems
by
to be
this court
making
which
its own
simply
finding
indicated
that
that
this
now
was a
that
gang
these
member
new guidelines
wearing
have
a
gone into
military
effect,
uniform.
defendants
And
can
what
raise
evidence is there in the
new
record
issues under 3582C to see whether it applies or not.
If I could interrupt you.
He had two independent points here. The substantive point was he doesn't win on the merits anyway because the district court imposed the gun enhancement. And two, this court should not be going ahead and vacating district court decisions under the guidelines
If I could
when there
direct
was
your Honor's
no
attention to
error
page
committed at the
163
time.
of the joint
because the
appendix,
district
when
court
on direct
followed the
examination, he
law
was
as it
asked who
was
came
at
the time. That is correct.
to his brother's house in the
Counsel,
second
could
visit.
you,
He said, like, Elmer,
dictate
the real bad
everything,
guy, and
your
other gang
argument,
members.
but could
You
you
didn't say
address
other gang
the
members, and in
improper
addition to this police
delegation
officer. So
argument that is
it's
made
a fair
with
reading of the
respect to
record
the,
that
drug treatment
these
facility?
people were indeed
Or
gang
drug
members,
treatment
but even if they
program.
were, even if
But
it was
the
just a
IJ
criminal.
had
District court
found
imposed
otherwise.
mental health and
The IJ
substance
found
abuse
out, I mean,
conditions. and
we
the
don't know
district
who
court
this
said
guy
he
is.
must
All they said
participate.
was he was wearing a police,
And then the
but
written
we don't know his
judgment
name,
indicated
his rank,
that the
so I mean,
probation
not
officer
how long he spent on the force.
supervised the provider
So I mean, and there's
location,
evidence in the
modality,
record
duration, and
that
intensity of the
impersonating law enforcement
We would
officials is a
submit
problem in
that
Honduras.
Correct.
So, I mean-
It
Ellis and
looks
Van
like,
Dunk,
it looks
you
like
wrote
the
the
board's
decision in
making a
Ellis.
factual finding.
The Nishida decision from
Most
the Ninth
respectfully, I
Circuit
think what the board
has
did was say the IJ's factual finding that this was a police officer was
And it has
unduly
said
speculative,
that
and the petitioner
type
did
of
not meet his burden of showing that this person was in fact a police officer. I mean, that's pretty much, that's
never says that.
I mean, that's what, that's the way the government reads the board's.
Why do we need to get into whether the probation officer can do an inpatient or
When we
outpatient?
read like
call.
the speculative thing,
As I
as
understand it, the
the word
supervised,
speculative is another way of saying you didn't meet your burden of
release order was
showing
completely
these things. That's the way
silent.
we read it.
On the question
anyway.
of
Can I
whether
ask you a question about
inpatient
what the
treatment
board said
was
here? Because
required.
honestly, I just.
Well, I agree with that, Judge Wilkinson.
literally don't
Nishida,
know
on the
how to
other
make
hand,
sense
seemed
of
to
these
think
two
that
sentences
even though there
together.
was no
First, the board
specific
says,
reference to
the immigration
inpatient or
judge relied
outpatient
on the testimony
treatment services,
that someone had
it was sort of
police
implicit
uniform
enough that the court could hold that
and
there was a
that someone
improper
declared
delegation.
Well, but
that the gang had the
as a
military's
matter
full
of
support to kill
text,
his family.
I did
And then
not
in the
think that
next
the
sentence, the BIA
supervised
says
release
it's-
order
BIA says that it's speculative
directed one
to
form of
conclude
treatment as opposed to
solely
another.
based on the
It didn't,
uniform
and that's why our
that he's a
argument
member
is
of the
that where the
police,
text is
acting
silent
under color of law. But
and where you
the
have
BIA
two
itself
plausible
just said the
constructions
IJ
of the
relied on
text.
two things: the
The
uniform
doctrine
and the
of to
statement.
avoid
And the
constitutional doubt
statement
is that you
seems
construe
like
the
pretty
provision
compelling.
in
If you're
order
trying
to
to show
avoid
acquiescence
a
and someone
constitutional
is
problem, here
literally
the improper
saying
delegation
the gang
of authority
has
to
the
the probation
military's
officer.
full support.
So yes,
to
our
kill
Does
his
that mean,
family
counsel,
members.
that, I mean,
I mean, the statement's
hypothetically,
like
if
doing most of the work
probation
there, as
here
I
were
understand it, and then the
to
BIA just doesn't address it
say
at all. It says
as
they only
part
relied on
of
the
carrying
uniform.
out
I literally don't
what
get what's going on.
might
here.
I
otherwise
believe what
be
your
ministerial
Your Honor is asking, correct me if I'm wrong, are you asking me if the board erred in saying that the IJ's color of law determination was speculative?
Your position is
I'm
that's
asking
not
whether,
what, that would be
I mean, the BIA
inconsistent.
did err
with
when
the
it said that the
text
IJ relied solely on the gang members' possession of a military police uniform, and I guess I'm
That is correct,
suggesting
Judge Quattlebaum.
that the
Again, if at some particular
BIA
point later
erred by
on down the
failing to
line,
address the
when
very significant
Mr.
evidence
Williams
that it
gets
had
out of jail, which I
described in
believe
the
is some 20
preceding
years from now, and he's already
sentence, the
47.
Okay,
If
what I
the probation
believe what the
officer
board was
were to
getting at
order
was, I mean,
inpatient
by
services,
citing
he
the
would have a remedy at
JGR
that
decision,
point.
which came out a
He could
couple
go
months
back to
after
the
the
district
immigration
court
judge
and say, hey,
decision,
this seems to
I
be
mean, the
improper
board was
under case law.
essentially
All we're
engaging in
saying
a
at
color of
this
law
point
analysis.
Is that
So, I mean, and the board was
language in the
essentially
written
saying
judgment
that, like, just wearing
nothing
a
at all
military
about
uniform
inpatient
and,
or
for lack of a better
outpatient
word,
services. So we
mouthing off
disagree
and
with
saying,
Nishida
making
to
these
the
threats that,
extent
like,
it said,
the
well, we're
military's
gonna
got
infer
the
that
full
it's in
support
there
to kill your
anyway.
family is not, engaging in misconduct is not sufficient to show
let's suppose
color of law. I mean, I've
they
looked,
were
I looked in
arguing
every
that
context.
by
Immigration, I've looked at Federal Tort Claims Act cases, I looked at Section 1983 cases. There's a wide body of color of law, and I can't find a single decision that even remotely comes close to what petitioner is asking right now, that like just showing up in a uniform and threatening to do terrible things when you're accompanied by people who clearly are not. They were accompanied by other gang members, criminals, I mean, and engaging in terrorist acts. I mean, there's no sort of official duty here. And going back to what I said about we don't know who this guy is he a patrolman? I mean, a rookie patrolman saying the military's got the gang has the full force of law to do that. I mean, if he was a commander, maybe someone who actually has that type of authority, but we just don't know anything about this guy.
Because it kind of
Judge
seems
Wilkinson,
like
our position were to be, if you were to find
that the
that
statement
there was an
would lend
improper
support to the
delegation here,
idea
following the
both that he's
language
actually
Well, I don't
in
want
the
to say whether
police,
it's
'cause he's sort of
court in
the
that
way your colleague
sentence
does is saying,
indicated
look,
that
the military police is in full
that,
support of what we're doing here. So A, don't bother complaining.
inpatient,
And B, if you do, we'll be back. Like it kind of seems like he's trying to leverage
it's silent.
his
But let's
official
suppose
status
that the probation
advance the
officer
persecution.
ordered
I mean,
the
again, I
inpatient.
can't find a single decision that supports that. If this court upholds
Okay.
that, I think it'll
Is
be the
that
first.
an improper
Petitioner
All you
cites
would have to do really is say maybe
delegation
the BIA should
at
say
that point in
something about
time,
the statement.
as long
I
as
mean,
there
I
is a
suppose, but I mean,
remedy
again,
and recourse can be had to
obviously, the court,
to
I
the
mean,
district court.
you're the decision makers,
Well,
so I mean,
that's a very
I don't think you should
complicated
send it
question
back,
dealing with
but.
the
I agree, it's a
So,
very
but
complicated
for additional
question, which is
fact-finding, I mean,
why I
all right,
asked
but
you.
I mean.
Well, our
but,
position
even going
is
back
that
to the
at
other
any particular
acquiescence,
time
I
it
mean, like,
appears in
again,
the record
this
that the
Los Chirinos
probation
is
officer
terrified
is
of being
making
caught by
the
the police.
decision
And so that this court has
as
said
to
repeatedly
make,
that when bad guys
inpatient
express
treatment,
fear
that
of
is
being
incorrect.
caught, they
There
know
should
they
be a
can't
remedy
operate with
at
impunity.
any point.
The record
Now,
shows
if this
most
court were to hold
Chorizo's
that in
members
light of
are in
the
jail. If
language
they
in
have
the
the full
particular
support of the
written judgment in
military,
this case,
why can't they do whatever they want?
authorizes
So, I
the
mean,
probation
and-
officer.
Your position here is the issue is just not right.
Not saying not so much as right, but simply that the
BIA
text,
did
there's
say that
nothing
the
in the
police
text
were helpful and
of this
responsive
Right,
to
but they
it.
didn't say anything
the
about our
supervised
case law
release
and this idea
conditions
that, look, if
that would
gang
allow the
members are showing
court to say that it
apprehension
does authorize a
about being turned
probation
into the
officer to
police, then
order
the police
inpatient treatment,
aren't
because under the
acquiescing.
doctrine of
I mean, we don't-
constitutional doubt, if
BIA
there's
didn't say anything
more
about
than
that.
one
Well,
plausible
again, I mean,
reading
it's-
of the text
the
or
BIA
supervised
did
release
make
condition,
clear that, like,
you
there
want to
was
pick the
no
one that
acquiescence here.
avoids
And so, and
constitutional
again, the
problem.
BIA
So
also
we
did say
in
that
this
the
case,
police
because
were
there is no
responsive
specific
to the family every
requirement
time that they
the probation officer order
they
inpatient
asked.
or
And so, I
outpatient
mean, like,
treatment.
when
You
his
construe it as to not give
one of
the
his brothers was
probation
killed,
officer
the
the
investigator and
authority
the
to do
coroner
that.
showed up to
You're
do their
telling me
duties.
that this court is going to say
And
that we
when
are going to
petitioner
construe it the other way.
when
I
petitioner
would
was shot,
acknowledge,
the
as I
police
did in
did
my
like
briefs,
attempt
that a
to
bunch of
go
several
apprehend or
courts of
question
appeals have held
Felix, if I
that a
pronounced his name
probation
correctly.
officer
He wasn't
cannot
home, it's too
order-
bad. And so,
cannot order
anyway,
inpatient
but
treatment.
unfortunately, petitioner,
What did the BIA
There's
say
no
about what his
inpatient,
mother came?
outpatient.
I mean, do you
language.
agree with those decisions?
It's a hard question for the government, in as much as those
Was there any mention in the
provisions don't
record in
appear
terms of
here. I
BIA's
would like to
decision?
defer an ultimate
As
answer, but I will
to
acknowledge
following
that
up.
the bulk of the courts of appeals have
what the
said
board did say was that, like,
probation
the police did
cannot
not continue
order
the investigation after
inpatient,
petitioner had taken
treatment
off.
of
And so
supervised
the mother
That'd
yet
be a
did,
pretty big
apparently,
decision.
there is the
I know the
record.
mother did. The question is, did the
Direct,
BIA
but
even acknowledge
rehabilitation
that?
would be inpatient.
I don't believe the BA actually
because you-
mentioned the mother, but I mean, again, I mean,
In essence,
if the
directing a
police don't have a
formal
complaining
confinement.
witness, I mean, there's very
It
little
would be a
point
very
to
difficult
continuing
argument for the
investigations.
government
I mean, if the police did tell the mother, hey, if he comes back, we'll
Okay.
continue with the investigation.
But
I mean,
I
this court said
understand
in
where
What I am saying is
To
in the
be
text of this supervised
a
release
serious
condition, inpatient,
Family
outpatient
members have to
treatment is
die.
not
Yeah,
there,
that's what- 'cause
and
you're
this
saying
court
that
should not interpret it to allow
this
the
record
matter.
here,
It's
probation
certainly a serious
officer
matter, but
to
we're
authorize
talking, like, the police,
you don't
I'm
wanna be
sorry,
dragged- you don't wanna be-
we don't know
you don't
why
wanna be
exactly
led into the
the
more difficult
gang
questions, do you?
It's a very
shot the
difficult question. The courts of
the
appeals
second
have
brother,
pretty much
second
said
one.
that probation officers
But
cannot
the
order.
petitioner theorized it was Los Choritos, that
Well, I do have
the
this. I would
gang
like to address some
shot
questions with
the
respect
first
to the
brother
sufficiency
or
of the
burned down
evidence.
his house because he refused to pay extortion.
The
So
evidence is
neither one of which has
sufficient
anything to do with
on
petitioner.
theory.
So other than the
so-
fact,
Pinkerton
just
theory.
Is it the government's
Constructive possession of the
position?
drugs
I guess it is, that the
requires dominion
petitioner
and
could
control. It
have
doesn't require that the
safely,
defendant actually reside
after
on
he
some
was shot,
premises. The evidence here
turned
was that
home
Tayon owned
and
at
gone
least
to
some
the
of the
police
drugs found at
station,
the
that he could have
residence.
safely done that?
Tayon and Scott jointly sold large
yes, I mean,
quantities
so,
of
the police
marijuana
seem
and
to be
other
responsive
drugs.
to him.
Smothers
And
was
so,
their
I mean,
supplier.
and so it gets his burden to show that they would not have acquiesced. So, I mean,
No, I guess I'm not really
found at
asking
the
about
house had
acquiescence.
his
I'm talking
nickname
about
on
the
it,
part where
and some of the marijuana strains that he
the
favored,
mother
like
is
number
told,
2
like,
in
we
the
won't
OC,
pursue this unless
were
your
in the
son
room.
comes back
Tayon
from
had
town where
directed
he was
Cox and
just
Diaz
shot
to
and
travel
where
to
his
Scott's
family members are
residence
being
to pick up drugs and
systematically
leave payment.
raped
And then there was the
murdered,
jailhouse
and
call in
shows
which
up at
Tayon
the
got mad at
police
Scott for
station.
leaving drugs
That's
in the
what
house,
he needs to
which
do,
showed
and the
his knowledge
government's
and
position
possession.
is he could
You
have
take
safely
that
done
evidence
that. I'm
viewed
not
in the
talking
light
about
most favorable to
acquiescence,
the
I'm just
government
talking
as a
about
whole
his
about
odds
his individual
of
pieces
surviving that
that
trip to
supports
the
the
police
evidence
station.
under either a principle or a
so I don't, I
Pinkerton
mean,
theory.
my
Do we
time
need
is
to
up. Can I
find
answer?
that there was
Please.
sufficient evidence
Answer
that
that.
Tayon Williams
Yes.
possessed both cocaine and marijuana? Because
Well,
I see no evidence
Yes,
of
I mean,
cocaine
our
possession.
position is
There
the
is
petitioners must
evidence
meet their
that
burden
he had
to
asked
show
what
like
he
lack
was
of governmental
selling.
acquiescence. We can't speculate. We
There
can't
is
speculate.
also
The cases that he
evidence
cites,
directed, I
the cases that he
believe,
cites, I
one
mean,
of
like,
his Confederates,
were a lot more, like,
to get
there was
some
a lot more
cocaine at the
extensive
residence, and
evidence
there
of
was-
Was there evidence of
governmental,
cocaine at the residence?
There was evidence they seized about-
intertwined
I have
with
to remember, about
with the gangs, and so they were
250
personal to that actual petitioner. Larry Vargas spells this out. It's a 2023 decisions cited in our brief. So, I mean, you need more than a belief that reporting to the police would be too dangerous to argue futility. So, but, I mean, again, the police, I mean, like, as I said earlier, there's very little point in continuing investigation if they don't have a complaining witness to see the case to justice. So,
The government
All right,
says Mullen
thank you, Mr.
is irrelevant. I call this court's attention to page 298 of the Mullen decision. which is an alternative holding, assuming arguendo that no violation of the Fourth Amendment rights of the petitioners occurred, there is nevertheless a statutory prohibition
3 points on rebuttal, Your Honor.
against the agent's conduct.
First, regarding internal
which requires us
relocation,
to
the board was
reverse the
wholly
court's
silent on
judgment.
critical and unrebutted evidence
Counsel, does
regarding
it,
Los Chirisos' hunt for Mr.
appreciate
Funes
that.
in San Pedro Sula. They were
appreciate
silent
you
on
saying
the
that.
fact that
I'll call
multiple
that
family
some
members
witness, but I
were
wanted to go
nearly
to a
drowned,
different
had guns
question.
put in their mouths, guns
Does
held to
it
their heads.
matter
They were
in
shot and
your
threatened in order to find
invocation of
Mr. Funes.
3109
They also,
as to
in
whether
those instances of
the
torture,
motion to
received the
suppress
address of his
was
son,
based
who
on
was in
that
another town, and
statute?
threatened to go kidnap him
It
if
was
Mr.
based
Funes
on
did
both
not
the
return
statute
to his
and the
hometown.
Constitution in
This gang is
In
able
the-
to travel,
does
and
the
they
motion cite
demonstrated
the
that
statute?
It
after
does.
Mr.
It was a
Funes fled.
supplemental motion, and the court ruled
The
on
board was
both.
completely silent on the fact that the
If I could
gang
turn
went
now
to San
to
Pedro
the
Sula,
question of
they
whether
questioned
the
his
district
landlady
court,
about him, and on a separate
made
trip,
a
so they were able to go
specific
multiple
factual
times,
finding by
murdered his nephew
preponderance of the
William, with
evidence
whom he
that
was
the gun
living
was
while he was
possessed
in
in
San Pedro
connection
Sula.
with drug trafficking.
This court has never
If you read
posited
the one
and could never
sentence in
posit a
isolation,
test where one
sure, one
relocation
can infer that.
automatically
If you
defeats a
read the
CAT
court's
claim
statement
and not
before
and not
that, the
account for
court was applying
changed
the
circumstances
not
and the
clearly
development of the
improbable
record,
standard. That's the lens
such as
through which
when
the
was
court
here.
was viewing it. The
or where
Bolton
applicants would need to
case,
try and
which this
relocate
court
multiple
decided
times.
regarding the safety
This is
valve,
not the standard, and how could it be?
5C1.2
How many
specifically
times must one
said,
try and move?
just
How long do
because
you have to
the
stay
court
one step
applies
ahead of your
2D1.1
torturers before it's considered
doesn't
enough?
foreclose
How many
the
relatives need to be
safety valve,
shot,
which is
drowned,
exactly
or killed
virtually
in order to
identical
find you?
language to 4C1.1.
Furthermore, to justify the reversal of the IJ's past
Regarding the
relocation
delegation
finding based on anything beyond the three facts
word
cited by the board in their
modality
decision is completely
typically
impermissible under
coupled
Chenery.
with Location.
Regarding
The only
acquiescence,
way one
the board
can do
impermissibly
that
found a new fact
would be that
when
it
they found
could
that the Honduran
include
military police
inpatient
officer
versus
was
outpatient.
not who
I cite
everyone,
the-
including
if
DHS,
the-
said he
as-
was, and they
as
gave no citation to
stated
anything in the
at
record to
the
justify this
sentence.
speculation. This fact finding was not allowed, and thus the board's
To add to that,
quote-unquote
if the
finding
written
on this matter is not due
judgment
any
includes
deference.
a parenthetical,
This court has already
would you be
rejected
making
the
a
argument that
delegation
any
argument?
attempt to
If the
control
written
non-government
judgment
actors
did not
or
include the
any
new
fear of
language, I
any
would not.
authorities at any time
It
would
turns on those
categorically
5
foreclose a
words
finding
in
of
particular
acquiescence.
modality and location. I cite in my reply brief, I believe.
The IJ had found
government
significant
report.
findings
What
here
about your
regarding
adversary's
the
position,
torture
or at
and
least his
systematic murder
advocacy
of
a-
multiple family members
a
of Mr.
rule of
Funes?
construction,
His
which
brother
is
almost
that
died
in the
and
case
then had to give up
of
his address. And
ambiguity,
as mentioned, Los
you,
Chorizos were willing to travel to find
any
Mr. Funes
court
and his son.
should,
Finally, in defending the board's
under
erroneous
a
decision,
mash
the
wonder
government
or
ignores
whatever it
Chenery
is,
and takes that
we
too
should-
far.
we should
They attempt to rehabilitate the board's
interpret this
decision
in
on the
a-
basis
in a
of
manner
facts
that
the board did not
avoids
rely on.
a
This
difficult
court discussed
constitutional
this
question.
extensively in
And
Cordova.
so,
This court cannot
you
affirm
would
the
have to
board
make
on the
the
basis of
argument
reasons
that
that the
this is
board
a
did not
very
itself put forward.
clear
The board's decision must
delegation,
stand or fall on its own merits,
in
not
order
the
to
arguments
get
the
out
government
from
marshals
under
at this,
Mr.
at this juncture.
suggested rule of
The
construction.
government
Oh, I
bases
think
large
he's
amounts of
turned
its
it on
argument
its head.
on
I think if anything,
dicta
the
and holding from
constitutional
other
avoidance
cases,
and
unpublished cases,
constitutional doubt
including
doctrine
Larios Vargas.
supports my argument
And
because
in this
that's
case, Your
the
Honor,
whole
substantial
point.
evidence
If
does
the-
not
if
support
you
the
have
board's
language
decision,
that could be
and it was replete with
interpreted, I think it
legal
can
errors
only be
and
interpreted. May I
complete
continue?
silence on the facts of this
But may
case.
only be interpreted.
It is not fair to say that
modality has to
the
include
murder and rape
inpatient
and burning
versus
down of his
outpatient.
brother's
I
home
cite a
was
government report,
unrelated
and
to
there are
Mr.
many other
Funes.
things out there.
He has
Yeah,
lost
but if it's
most of his
silent,
family
if
there,
an order-
and
if
the
a
fact that he has been
supervisor
in
needs
detention
order
this
is
whole
silent,
time
we
and
can't
has lost
shake
some
it to
contact
try
with
to
his
make
family
some
should not be held
noise out
against
of it.
him in terms of
I
saying
think you have to
that
shake it. That's what the
I don't wanna
constitutional
shake
avoidance
it.
doctrine
It's
is
enough to
all
show that
about.
some
If it
family
could be
members
interpreted
survive
that
in
way.
Honduras.
If this court were to say in an
In this
opinion,
case, due to the
we
board's
do
significant legal
reinterpret
errors,
this language
their
to mean
decision that is
you
not
can't put
supported
a
by
person
substantial
in
justice,
inpatient without the district
substantial
court's
evidence,
approval.
we ask that this court
Fine, I'm
remand
good
this
with
this
that.
case to the board. Thank you.
All right.
Thank you.
Thank
you, sir.
Thank you very much for your presentation.
Mr. Guillaume,
We're going to come
we
down,
have
greet
some,
counsel, and we'll ask the counsel in the next
rebuttal
case.
time here.
Give us a little time to
Again, Mayor, please sign the
prepare
report. I want you to briefly
counsel's table for the next.
address two
come
points
down to
raised by
counsel and
government counsel.
proceed
The first,
thereafter.
acknowledge that I understand that it is a high bar for this court to set aside a jury's verdict. However, it is I think, given the facts in this case and the record is very clear, I think that the court can be very comfortable in doing that. With respect to arguments made by government counsel, specific to the drug ledger that was found in Mr. Williams' residence, I would argue that the drug ledger is nothing more than proof that Scott Williams was in fact involved in a drug conspiracy with his son, Tayon Williams, of which we have not contested, and the jury verdict came back as such. But again, as I said earlier, the conspiracy lasted from October 2017 until April 2018. This raid on the Mr. Scott Williams' home is apparently 2 months afterwards. And with respect to the jailhouse call that was played at trial, all that call shows is that Mr. Tayon Williams is aware that his father sells drugs and mentions that, chastises him, I guess, that it's his fault for having drugs in his home when it's searched, Your Honor. It doesn't imply that the drugs were his, that he became to learn that they were there based on Mr. Scott Williams telling him that they were there, and it has no implication with respect to his involvement with those particular drugs, Your Honors. Other than that, I do not have anything further, if the court has no further questions for me.
All right, Judge Crowell, Judge Barron, we have no further questions. I do see that both of you, Mr. Newton and Mr. Guillaume, I see you're both court-appointed, and I'd like to express the appreciation to you both from the court for the fine job that you've done this morning. And we'd like to come down and say hi to you and then move right into our next case.
Thank you, Your Honor.
All right, Mr. Vangelo, let's hear from you, sir.
Good morning, Mayor. Paul Vangelo on behalf of the appellants in this case, Your Honor. May it please the court, we are here before the court today claiming that the trial court deprived my clients and our clients of their Fifth and Sixth Amendment rights.
Okay, I like to ask everybody to speak up, but I'm very interested in what you have to say, so please speak up.
Sure. Again, we're here today to ask the court to bring the matter of the jury instruction of duress back before the trial court. We believe that by failing to have that instruction issued, the court violated our client's Fifth and Sixth Amendment rights.
Now, Mr. Vangelo, this was this trial took 8 weeks.
Correct.
That's a very long time. I realize there were a number of defendants, and that's part of why it took as long as it did. But, a lot of work goes into an 8-week trial on the part of lawyers, on the part of witnesses, on the part of jurors, on the part of the judge. So there has to be something really wrong to reverse and say, try this thing over. So you've got all these different issues, but was there something really wrong about this trial? Can you sum it up? Why it seemed everybody had a fair shot?
Well, Judge, I listened with interest to your statement in the last argument in which you said you don't want to keep the truth from the jury. And that's what we believe happened in this case. And I have the utmost respect for the trial court. But I hope you folks have had the chance to look at the video in this case, because that's incredibly instructive and critical to our case with regard to whether or not these people engaged in the racketeering acts voluntarily, whether they had the specific intent to commit the racketeering acts to maintain or increase their position in the enterprise. By not being able to argue the facts to the jury, we were deprived of a critical part of the case. And this is where our argument lies. That video, if I may ask if you've had the opportunity to view the video, because it's a very disturbing, grotesque, nauseating thing. But our position is, if you're present at the time and given the gang imperative to follow all orders at the cost of losing your life, then you're not there voluntarily. You're not agreeing to be participating for the purpose of maintaining and increasing your position. You're participating because you don't want to die. That video will show a person being chopped up into an unidentifiable bloody mess. And those present are within striking distance of somebody wielding a machete. That's the dynamic of the case. And that we were not able to argue, at least to argue to the jury, that their will was overwhelmed or overborne, that they could not have formed the specific intent to commit those racketeering acts because it wasn't because they wanted to maintain or increase their position in the enterprise. Rather, it was because they didn't want to die. And the historical racketeering evidence that the government brought in also had 2 murders and 1 attempted murder. And pictures, again, were brought up of decomposing bodies on the side of a river. Now,
Are you making a 403 argument here, or is this a Vicar argument?
it's both, Judge. I mean,
Is it both?
Yeah, we raised the 403 issue because we said that the media evidence was not necessary to the government's case. All right, it wasn't necessary to the government's case. The jury was revulsed at the media, and they asked the judge to please warn them next time when some of that media would be offered into evidence. I mean, they were disturbed. The jury was disturbed. They weren't present at the scene of the crime. Now, for us not to be able to argue that the threat of death, which was real and immediate, overwhelmed our client's ability to resist or to not participate, we were essentially left without what our critical defense in the case was.
Don't you have to show, I mean, the duress instruction elements, are set forth in our Crittenden case, is that right?
Yes, sir.
And you have to show all 4 of those elements?
That's correct.
And one of those elements is that your clients did not recklessly place themselves in a situation where they would be forced to engage in criminal conduct?
That's correct, Judge.
And you think that there's, that record supports that element?
Well, I do, because it was brought up in passing as a matter of history. So what happens with a typical gang member family in El Salvador? It's a broken home, father's missing, mother comes to the United States to earn a living and send money back. Right. The kids left, they're like 12, 13, 14 years old. They're left with the grandparents who have absolutely no control over them. The gang comes knocking on their door and says, you will join us. They don't offer a discounted 3-year membership at 20% off. They say, you will join us, because if you don't join us, we're going to beat you. We're going to beat you. We're going to beat you with our fists. We're going to beat you with our baseball bats. We may harm your family. So they are compelled from the very time they leave El Salvador to understand that if they don't comply with the rules, they might die. And they have perfect proof of that when they get here and they see 2 murders that happened in front of them. Mendez was the first, and then Terminio.
If that justification permits the duress instruction, you would say that instruction must apply in every MS-13 situation?
I think it would be.
It sounds like you're saying in all this gang activity, that's automatically the way the gang culture works, and you're automatically entitled to duress. You don't have any role in deciding it. Maybe true. I don't know. I know these are really difficult
My understanding.
circumstances, both in El Salvador and here, but wow, that's a pretty staggering sort of
It's
argument.
broad, but my past experience with MS-13 cases in my district is that we've gotten the duress instruction. We've had differences of opinion about the formulation of the duress instruction, but we've received it. And again, that video, I think if you haven't seen the video, I can't.
Can I just, on the video and the photographs, in this day and age, we all walk around with a video camera and a camera in our pockets. And so this seems to me an issue that will appear in many, many cases, if not every criminal case going forward, that crimes are being recorded and that then can become evidence. And so this isn't a situation that's unique to this case. I think what perhaps you're raising is that the gruesomeness of the acts are depicted in the video. But you're not making, there's no argument that the
is that together with mens rea, as we all learned our first year in law school, those two things are critical to criminal proof. And here you want to disable the government from putting on actus reus evidence and say, the more horrible these things are, the less you can talk about them. And what kind of trial is that? Not one. Not something that resembles a trial. It begins to resemble a one-sided affair. And that's my problem with your Rule 403 argument. It just leads in the wrong direction for these terribly heinous acts.
I'm not here to dispute the nature of the acts, Judge, but.
You can respond now, or you can wait for your rebuttal. I'm happy for you to respond whenever you want.
I'm not suggesting that the government can't put its evidence on, as it did in this case. What I'm saying, we should not be constrained to not be able to argue whether duress was present and whether the jury should find that they had a defense. That's what our argument is. We're not saying that government can't put its evidence on. And it was a ton of evidence that we would argue that was unnecessary to the proof of the charges in this case.
Okay.
Thank you.
Thank you. Mr. Beers.
May it please the court, I'm Paul Beers. I want to thank the court for appointing me to represent.
I know you've got a little limited amount of time here, and I don't mean to take it up with a question, but.
Yes, Your Honor.
But what concerned me about this was, as I say, it was an 8-week trial, and I wouldn't want to put anybody through it again from a standpoint of lawyers, witnesses, everyone else. But most of your claims
Yes, Your Honor.
seem to me to go to to basic trial conduct questions that sort of what district courts do in any trial. They were a lot of your claims were evidentiary claims. It was subject to an abuse of discretion. Others were sufficiency claims, severance claims, instructional error claims. But all of these different claims are matters that are classically matters of trial court discretion.
Yes, Your Honor.
About 9/10 of the claims are the trial judge makes the call, the standards of review protects that. And why? I mean, something would have to go really haywire in order to put people through another 8 weeks. I just don't, I mean, and these are trial court, run-of-the-mill trial court judgment calls that you're talking about.
Thank you for the question, Your Honor. I understand the court's position. I think our position is that this was beyond, this was a 14-year-old boy on film being hacked to death. It was so disturbing to this jury that the judge abused his discretion in allowing it in. It was unnecessary to the government's case. And so from that perspective, we think there ought to be a new trial, as my colleague argued. I was not at trial, Your Honor. In fact, I didn't even write the opening brief. My colleague, Mr. Kunyanaga of Alexandria, passed away. So I'm from Roanoke, and I was appointed subsequent.
Counsel, can I
Yes, Your Honor.
ask a question? And if this is more directed to your colleague, I'm sorry, maybe I'll just deal with it on rebuttal. But
Yes,
I want
sir.
to ask about the expert witness issue. Is that within your bailiwick of this argument?
No, sir.
Okay,
I think
I'll hold off then.
Mr.
Thank you.
I filed a supplemental brief after I got involved, and also a Rule 28J letter concerning the Rogers issues. There are 2 Rogers issues that are closely related. One concerns the standard conditions of release. The Eastern District of Virginia, in this case, the judge, Judge Ralston, simply said, I want you to comply with the standard conditions of release adopted by this court. That is a clear Rogers error after a case called Smith and Alcorn versus the United States, September 23 of this year. In that case, Judge Jackson did the exact same thing. All the judges over in the Eastern District have been doing that, simply incorporating the standard conditions of release adopted by this court. As this court found, it was Judge King and a concurrence by Judge Agee. That's clear error because the Eastern District has never adopted a set of supervised release violations. This judge, Judge Ralston, with all due respect, did the exact same thing. That's the first Rogers error. The second is there's an inconsistency between 2 of his special conditions, between what he announced orally and what's in the final judgment. The first is inpatient treatment, which can be very expensive. In announcing that at sentencing orally, he didn't mention any obligation on the part of the defendant to pay. But in the judgment, he imposes a duty to pay on the part of the defendant. And the other is something he just never mentioned. The judge never mentioned at sentencing. That is that you shall not use cannabis or marijuana in any form. And that appears in the final judgment. That is a clear Rogers error, and it's a material one because...
Well, there's a mandatory condition that you refrain from unlawful use of controlled substances.
Yes, Your Honor, I see that, but cannabis is around. I mean, people use it now for pain relief. It's perfectly legal. He says cannabis in any form.
So it's the any form you think that's inconsistent? If it wasn't any form, I guess you're saying it can be lawfully used.
I see my time is up. May I answer the court's question? Thank you, Your Honor. Well, I think in many states, it's legal to marijuana, and some usage of marijuana is legal. So that is not covered by the mandatory condition. I'd like to point out the government, to its credit, has conceded these points. So I would ask for a plenary resentencing in front of Judge Alston. My client has his own reasons for for wanting that.
And the Rogers errors are only with respect to the single defendant, is that right?
I only represent the one defendant. It is my view after a case called Mathis, it needs to be raised. It's a structural error. It's being raised. Rogers errors, I think, have to be raised, so I'm raising them. And I haven't looked at the other defendants. Yes, sir.
I'm sorry, I just wanted to make sure I understood what you said. I'm pretty familiar with Mathis.
Yes, sir.
What'd you say about structural error, and what's the implication of saying that?
I think that it has to be raised if counsel.
Yeah. Judge Berner's question was with respect to one defendant, and I was trying to figure out if you were debating that in any way.
I'm sorry, I got off track. The answer to the question is, I'm sorry, I don't know. I just looked at my client's sentencing transcript.
That was my question. You're only raising it with respect to your single client.
Yes, Your Honor. No further questions. This concludes my section of the argument.
Thank you.
Thank you.
Mr. Blanchard.
Good morning, and may it please the court, Alex Blanchard for the United States. For the reasons set forth in the government's brief, each of the 11 claims raised on appeal by the defendants falls short. The defendants have failed entirely to demonstrate that any of the district court's rulings were erroneous, constituted an abuse of discretion, or materially prejudiced them. Accordingly, the defendants' convictions, each of which was supported by substantial evidence, should be affirmed. I'd like to address the issues, or at least attempt to address the issues in the order in which they were raised.
I want to have to ask you to speak up too, Mr. Blanchard. I'm not hearing you.
Yes, Judge. I'd like to address the issues in the order in which they were raised here this morning, starting with the district court's refusal to instruct the jury on duress.
Counsel, I hate to do it because you have your order, but I'm going to get you out of order from
That's fine.
the start right here, if you don't mind. I wanted to ask about the expert issue that was raised, and this is what I'm just trying to figure out from a factual standpoint. Was the testimony from Guzman that may have come in as a expert testimony, was it opinion evidence or was it background evidence? Were there any opinion questions asked in the classic expert, kind of category?
I think it's fair to characterize Sergeant Guzman's testimony broadly as him rendering an independent opinion about the history, rules, structure, and so forth of MS-13 based on the body of the work that he had conducted over the preceding nearly decade.
But that's, normally you have expert witnesses and they're in the field of, that there needs to be expertise in. If you're going to ask a opinion, you say, do you have an opinion? And the expert says, yeah, and you have it to a reasonable degree of certainty, and you say, yeah, and then you can kind of evaluate the reliability factors that Dahlberg and other decisions talk about. It sounded to me like this was less of that and more almost factual background. Maybe I read it wrong. That's what I'm trying to figure out, whether this is I don't know that it ultimately matters in this case in terms of whether there was an error, but it felt more almost about relevance than, and whether you had knowledge, than whether this was really an opinion.
I understand your question, Your Honor, and would acknowledge that generally speaking, sort of in the conventional sense, yes, an expert is rendering an opinion on, say, the application of a particular scientific method. Here, the gang expert was called to allow the jury to understand things that lie beyond the average juror's understanding, and that lie beyond, it's important to note, the understanding of some of the actual gang members that were called as witnesses in this case, who, for example, could not speak to the history.
What was the opinion that he was asked to, what opinion was he asked to give? Was there a question which says, I want your opinion on something?
No, I don't think there was a question along those lines posed to.
So he just gave, I don't mean just, because it's important, but he gave factual information about background matters related to MS-13 and gang activities and culture. Is that right?
I think that's fair to say, Your Honor, and I think it's important to note that in this court's decision in Palacios and this court's decision in Ayala, authored by Judge Wilkinson, the very same type of expert testimony rendered by an investigator of MS-13 has been blessed.
But is it proper to declare someone an expert and then not ask opinion questions? Doesn't that give, some aura of expertise to what are basically facts?
I think that could happen. I don't think that's what happened in this case. And to answer one of your Honor's earlier questions, I don't think that this actually does matter as to the
Yeah, there was a lot of other testimony about that stuff. I'm not sure here it
To the extent there was
matters.
any error here, the government's position is that it was harmless.
As I understand it, this Mr. Guzman has been qualified as an expert by a good many other courts.
He had been qualified, I believe, approximately 5 times previously.
What?
About 5 times previously as an expert on MS-13 in state court in Texas. This was the first time he was qualified in federal court.
And his background was pretty extensive and not as to this particular case, but as to MS-13.
That's right, Your Honor.
Generally, and to the modus, it really was focused on the modus operandi of MS-13 and of gangs as a general matter.
Of this specific gang, yes, that's right, Your Honor. And it's important to note that the expert, Sergeant Guzman, was not given any information about this particular case. He did not testify about any of the particulars of this case. He did not know the defendants who were on trial. This was elicited both on direct and cross-examination. And so the contention by the defendants that he somehow was a transmitter of testimonial hearsay, and that he somehow rendered the trial unfair in the way that the Second Circuit found the expert in Mejia did, is simply not accurate. That's not what occurred here. Unless there are further questions about the gang expert issue, I will move to the district court's refusal to instruct on duress. Two of the defendants, Herrera and Elmer Zelaya, never proposed or joined one of their co-defendants' requests for this instruction. They did not oppose the government's motion during the trial to preclude the provision of the instruction. So as to them, this claim should be reviewed for plain error. But as a general matter, as the court knows, duress applies in very narrow circumstances, and defendants who seek to assert it face a very high bar. Here, the defendants failed utterly to clear that bar. And as Judge Quattlebaum mentioned, there are 4 factors set forth in this court's decision in Crittenden that have to be shown. And in order for a defendant to put that instruction before the jury, there has to be a threshold showing, is what the Supreme Court has called it, essentially a prima facie showing that these elements actually can be satisfied. Here, there was none of them were satisfied.
Let me ask a question about Henry Rodriguez, Henry Martinez, okay?
Yes, sir.
And the sentencing issue there. I think the government conceded that there was a Singletary-Rogers error here.
That's right.
And that's the only error that you've conceded on?
Correct, and only as to that defendant.
Only as to that?
Yes.
Is your view that the entire sentencing of Henry Rodriguez needs, it has to be a complete resentencing?
The government is constrained to agree with the defendant that plenary resentencing is required here under this court's precedents in light of the Rogers
Okay,
error.
but is there anything that would prevent an appellate court from commenting on the general sentencing? And on, well, I know that specifically an Eighth Amendment issue was raised, and the rest. Is it permissible for an appellate court to say, okay, there's a Rogers-Singletary issue here, but these other questions have been raised and we see no error with regard to those?
I think that would be appropriate, Your Honor. And just to make clear, the Eighth Amendment issue, or challenge rather, was raised by a different defendant than the one.
Oh, yeah, okay. Well, but I mean, whatever, I'm talking about Mr. Martinez. If he's raised some other. for a court of appeals to say, yes, these other aspects of the sentencing were conducted fine, there was a full explanation, this and that. And that saves us and the district court the whole question of another appeal on those things. So I'm trying to say that I understand Singletary and Rogers and the need to conform the written sentence in the supervised release conditions to what is orally pronounced. I understand those, but I don't think that we should imply or indicate if we don't believe it to be the case. I don't see an impediment to commenting on sentencing issues that are raised by Mr. Martinez otherwise, other than the Rogers Singletary.
The government agrees, Your Honor. Returning briefly to the issue of the duress instruction, as I mentioned, none of the elements were satisfied here. There was no imminent threat of death or serious bodily injury. This court has held repeatedly that a general fear of reprisal is insufficient. The defendants placed themselves...
Of course, on remand on a Rogers and Singletary issue, you would give the defendant the chance to take exception to the condition that was omitted in the oral argument, but was included in the written judgment. The defendant would have the ability to take exception to that one particular condition. Am I right?
Yes, Your Honor.
And that's it. That's the remand.
It is a remand for a full resentencing, and...
Yes, I understand that, but there's no impediment to saying that the Court of Appeals, to resolving the other issues and saying that we don't, if depending on what we see in them, that we do or we don't find any error.
Certainly.
But the error that needs to be addressed, even in the context of a full resentencing, was you need to square the written and the oral pronouncements with respect to the supervised release together. And to the extent that there's a discrepancy, the defendant would seem to have the right to say, well, I listened to this. I didn't understand this was a condition until the written supervised release order came in. I'm objecting. And then the district court can clarify it. I just want to make clear what it seems to me from a matter of common sense, what a remand should entail.
I think you're correct, Judge.
So like I said, I've written on this, so I'm not sure where common sense, fits. But I think Judge Wilkinson makes a point that on any raised issue, I think we have full authority to address any raised sentencing issue.
Correct.
But, whether it's...
But it's still a plenary resentencing.
That's just what our law says is...
That's what it says. Yes, Judge.
Can you respond to your colleague's assertions on the motion to sever?
Sure. There was nothing erroneous about the joinder of the counts in this case, and this was a paradigmatic example of an indictment that properly joined both counts and defendants. And the district court did not abuse its discretion, Judge, when it refused to sever under Rule 14. There can be no abuse of discretion in a case like this one where the defendant merely pleads jury confusion between defendants rather than demonstrating the infringement of a specific trial right. This court in Williams held that unless a defendant can show that a joint trial was so unfairly prejudicial that a miscarriage of justice resulted, a defendant can't overcome the presumption that co-defendants should be tried together. For those reasons, Your Honor, we believe that the district court properly ruled on that motion. Turning briefly to the issue of the so-called graphic videos, the murder videos, these videos were highly probative of the crimes charged, at least as they relate to the murder of Sergio Tremino. They placed 4 of the trial defendants at the scene of the crime. They corroborated cooperator testimony. They established the victim's identity. They showed the actual crimes being committed for the jury to see for themselves, and they demonstrated the defendant's intent, both their intent to kill, which of course the government had to show in a case charging murder, but also their intent to prove to higher-ups in the gang their worth in terms of promotion, because the very fact that the murders were being recorded, and it was known that that recording would be passed along, and was passed along to more senior-ranking members of
On
the
the
gang.
severance issue, these defendants were indicted together,
Correct, yes.
and so you have a presumption that if you're indicted together, you try together.
That's right, and that presumption can only be overcome if a defendant can show that there's going to be an infringement of a specific trial right. Here, there was no
So
such
you
showing.
was thinking about it, you have 5 defendants with, if we severed, would the witness, the same witness have to testify at 5 different trials, or?
That's right, it would be completely inefficient and an affront to judicial economy.
Or the witness, it would be quite a slog.
That's certainly right. Returning to the issue of the graphic videos, in Torres, this court held that Rule 403 does not preclude the introduction of evidence that didn't involve conduct any more sensational or disturbing than the crimes with which the defendant was charged. And I believe that my good friend on the other side, Mr. Vangello, conceded during his argument that here there was no daylight there, that the videos showed crimes being committed that were the crimes being charged. There was nothing, and Judge Berner asked a question about this, that would indicate there was something unfair about this because the video showed something exogenous to the crimes that were charged. Unfair prejudice speaks to the capacity of concededly relevant evidence to lure the fact finder into declaring guilt on a ground different than proof specific to the crime charged, and that's not what occurred here.
Counsel, the evidentiary issue about the testimony of Delgado,
Yes, Your Honor.
I'm not exactly sure if the argument is technically an hearsay argument or if it's something a little different from that. But was that, were the notes about the statements of the defendants offered for the truth of the matter asserted?
They were, Your Honor. There was a single note, and it only referred to Mr. Vangello's client, defendant Velasco. But in challenging the district court's admission of that note, the defendant doesn't in any way suggest that the government failed to meet the prerequisites for admissibility under 803.1. Rather, defendant Velasco argues that it shouldn't have been admitted because Mr. Delgado didn't need the note to testify about its contents,
Right.
and because it could have been read into the record.
So it's not technically a hearsay objection, it's almost like a, unnecessary or best evidence or something like that?
I presume so. I
don't even know.
don't entirely know, Your Honor, but what I
Right.
do know is that no authorities were cited in support of either of those contentions.
Thank you.
Unless the court has any further questions, the government relies on its brief and asks the court to affirm the convictions.
Judge Berner, do you have any further questions? We have no further questions, and Mr. Vangelo has some rebuttal time.
Thank you, Your Honor. Just briefly, I know there was a question from Judge Quattlebaum regarding the expert witness.
Right.
Yeah, and the, I'm trying to, his name now slips my mind.
Gomez, I think.
Yeah, he was a Houston.
Guzman, I'm sorry.
Guzman, I'm sorry. Thank you, Judge. He was a Houston police detective. His experience was out of Houston. He had some peripheral experience.
Well, that's fine. I mean, that's a grounds to object, and if he's doesn't have knowledge, you can object, and either that's an abuse of discretion or you can cross-examine him on his lack of knowledge. I mean, I hear your point there, but that quite frankly, that seems a little bit hard to get out of the abuse of discretion. I'm actually thinking about something different, which is, is this testimony actually expert testimony? And are we cloaking in expert testimony, which is, can have profound impact, testimony that's factual? Usually experts are designated so that they can offer an opinion. And I was trying to figure out, was there an opinion ever offered? And now, of course, experts who offer opinions can testify about background as to how they get there. That happens all the time. But, just to say I'm an expert and I'm going to talk about this seems unusual to me.
Well, I think the government conceded that there wasn't any opinion asked or offered.
Is that your understanding? You were there, right?
I was there, yes, sir. And had there been, in the past, I've had problems without going through the expert analysis to say, has a proper foundation been laid? And this is more like narrative background, but not really.
Well, it may be very relevant, but my point is it's factual. Right. And I may be just, kind of off on something that interests me that doesn't matter as much here, because that's not really the argument. It seems like your argument was he doesn't have the knowledge or sufficient knowledge to connect it to this case.
It was also part,
right.
What we thought his background was hearsay-based as well. So I wanted to reserve a minute.
With respect to the expert testimony, the very reason someone is called as an expert is because they have some relevant background as it relates to the case. I mean, they're not being called to just opine on some disconnected subject. And, in this case, the guy's whole background, practically 90% of his time in the past 5 years, has been spent with MS-13, not this particular gang, but the way they operated in Central America. And at any rate, the whole standard of review seems to kick in, doesn't it? And whether to qualify as an expert, or whether somebody's an expert witness or a fact witness, that's an abuse of discretion standard.
That's correct, Judge. But we did object, but our objections were overruled, and he testified, and he was subject to cross-examination. I want to say that we did get some important information from him, but it would have been in the context of, again, our request for duress instruction. I know Mr. Beers wanted to have a minute to respond to the Rogers issue, if I can hand off a minute to him. Court's permission.
Thank you, sir.
Thank you.
I'll even take a minute. I appreciate the indulgence of the court. I just wanted to address Judge Wilkinson's question about the scope of the remand. It's plenary, Judge. What His Honor was articulating is the argument that the United States lost in United States versus Lassiter, 96 F. 4th, 629. That was in March of this year. It's Judge Richardson's opinion. It's a de novo sentencing, and I think my guy, when we get back there, if he wants to argue, and I think we will, that there's an Eighth Amendment problem with putting him in jail for life, he can argue that. He can allocute anything. It's a brand new day. Thank you very much for considering my argument.
We thank you. Taken in the preparation of your briefs and argument. We'll come down and say hi to you.
May it please the court, I'm Daniel Lowe on behalf of plaintiff appellants, Mr. Dees et al. A fail-safe class is one in which membership is conditioned on a finding of liability, such as defining a class as purchasers that paid an antitrust overcharge. Here, by contrast, plaintiff's proposed fixed list class is not conditioned on paying an antitrust overcharge or on any finding of liability or any finding by the jury, but is based on being included in Appendix A of plaintiff's expert report. Inclusion on the list, and therefore membership in the class, is fixed and cannot change. The class consists of manufacturers who can rely on Dr. Grace's regression analysis as common evidence.
Counsel, aside from the merits of the fail-safe argument, the district court ruled on that proposed class in an earlier order?
Correct.
And then the class without prejudice, in fairness, but then, you proposed, or the plaintiffs proposed, the limited payer class and the all payer class, and then the district court denied cert on those two class definitions. And I know there's some footnote about alternative stuff about fail-safe, but it seems like the primary argument or that those two classes are the order you appealed from. What's your argument, I guess, as to whether we should consider the merits of the fail-safe since it was not appealed?
So the original order addressed the original class definition, and in the subsequent round of briefing, we did propose a revised version of the fixed list class. So it was a different class definition than was proposed in the original briefing and that was rejected in the original order.
So your argument is about what, and I may be calling these the wrong things, the all payer class or the limited payer class, and you're incorporating fail-safe within that? Or are you going back and arguing the definition from the earlier order should not have been denied?
We're appealing only the definition of the fixed list class that we proposed in the subsequent round of briefing.
Okay.
So it's a different definition than what was originally denied. And that was proposed at docket 287 at page 18, and that's a slightly different definition. The definition we proposed is based on the ability to rely on common evidence, and the Ninth Circuit.
I don't want to be, I'm sorry to belabor this, but I want to make sure you and I are on the same page. Will you just real quickly tell me the manufacturing definition of the class you're talking about?
The manufacturers, and this is quoted at Joint Appendix 2097, the manufacturers listed in ECF 257-25, Appendix A, is the quote, and that ECF number is the expert report of Dr. Grace.
Okay, and that's not the definition that says with observably higher shipping costs, correct?
Correct.
Okay, we're on the same page. Thank you for clarifying.
And the Ninth Circuit in Olean Wholesale recognized the appropriateness of defining a class based on class members' reliance on common evidence.
You know, it's your job to define a class, and I'm wondering, seems to me you got started off a bit on the wrong foot when you proposed to the district court that the class was simply going to be the different names that were in the appendix. And how does that you define the class as manufacturers listed in an appendix, but how is that definitional in any sense? And the rules are clear that you should define the class as soon as practicable. And that's important because it lets you know, and it lets putative class members know which class they're in and which class they're out. And it gives them the ability to withdraw and everything. And I don't understand how a list of manufacturers' names in an appendix can possibly be said to define a class. I mean, I realize we get in later to the all payer and the limited payer, but initially I just thought submitting a list rather than a class definition is a very unusual way to approach a class action case.
Your Honor, I think your point is similar to the point made by the court in Rivera, which is one of the cases cited by Inmar in this case. And in Rivera, the court held that it was improper to submit a list of names because that would leave the court to guess the commonalities between class members. Here, plaintiffs defined the class in connection with Dr. Grace's findings in Appendix A and explained in their briefing that Appendix A provided common evidence of antitrust injury and damages.
But you said then, oh, the plaintiff's list here was conditioned on members having suffered an antitrust injury in the form of increased shipping fees. But if it's conditioned on the finding of an injury, that takes us right into the merits. And having the class defined by success or failure to the merits is the very weakness that the very reason. I mean, one of the whole case seems to me to be an attempt to push forward a fail-safe class. And innumerable circuit courts have rejected that because the rules say that the class action has to be the best and most effective way of approaching the case. And it's not an effective way of resolving the case if people lose on the merits. They're thereby out of the class, and then they can bring individual suits. And that seems to me to run against the grain of the whole idea of Rule 23, which is if you're going to go the class action route, you need under Rule 23B to decide that this is the best way of resolving the case. And a fail-safe class is definitely not that. You see my problem?
We say that the class is not conditioned on the finding of liability. Class members will be bound by the judgment no matter what the result is. If the court finds that they did not suffer an antitrust injury, judgment will be entered against them, and they will not be able to bring a subsequent lawsuit.
One of the advantages to a class action for a defendant, from a defendant's point of view, is that you avoid the considerable drain on resources by case after case after case after case being brought by individuals. And the whole fail-safe notion that your conditional class depended on leaves the defendant open to individual suits if the class action, even if they win on the class action point. The people that are still free to go forward with individual cases.
Your Honor, the class definition is in no way conditional. It's a list of members who found by Dr. Grace to have met certain conditions, they will be members of the class regardless of whether someone else finds those conditions weren't met. The jury decision, regardless of what it is, will not affect the membership of the class. The class is fixed.
See, but I don't understand. It seems to me a lot of these manufacturing classes, whether they were fail-safe or whether they were all payer or limited payer, that I'm not sure what they have in common in terms of the proof or the common answers that could be given. And I don't know, it says whether these manufacturers paid shipping fees, when they paid the shipping fees, what shipping fees they paid for, what they didn't pay for, why the manufacturers paid the shipping fees, what particular defendants and coupon processors what were they really after and what weren't they? There are multiple defendants in the proposed class action with the coupon processors, and that further complicates the dissimilarity that's there from the start. And it's just in the disparate nature of the claims and the disparate situational position in which the manufacturers find themselves, it is I think Judge Osteen was right in saying that, boy, there are all sorts of problems with this over the horizon. I don't know which manufacturers have claims against which coupon processors and which don't. Honestly, my friends, they're just all kinds of commonality problems. And sometimes we remand for subclasses and everything if we think a class action has a shot eventually of going forward. But this one, this one seems to me to be just riddled with problems. There are standing problems, there are Article III problems, there are arbitrary class definitions that are proposed for arbitrary periods of time. There's just one problem after another, and they're just all piling up on each other.
Your Honor, the purchasers and for all the classes are manufacturers who made purchases during the class period from one or more of the defendants. There is joint and several liability, so each of the defendants is liable regardless of the purchasers. The standing issue is a separate issue from class certification and isn't part of this Rule 23F appeal. The plaintiffs will all rely on the same common evidence. There's not individualized evidence.
On the standing point, I realize that wasn't necessarily really addressed or framed, but we have an obligation to make sure we have Article III jurisdiction. And I know you claim that there's not a concession, that some of the class members aren't injured. But if you assume there's not, the record reflects that there's no injury to a third of the class members on the list, that under that assumption, you'd have a class with roughly a third uninjured members. And the district court ruled on that primarily on predominance. But in that, I kind of like Judge Wilkinson, I can see that, or at least some merit in that. But isn't it also a standing issue?
if I may respond.
No, please answer the question. I have the same question. Answer Judge Quattlebaum's question.
We don't agree with that assumption.
I know you disagree with the assumption. My first question is, accept the assumption. That's kind of why I asked it that way. I want you to accept my assumption that a third of the manufacturers aren't injured. Would we have a standing problem if that's correct? And then you have a next argument. I get you. I don't accept the assumption. Maybe you've proved that, maybe you've not. But under my assumption, do you agree we have a Article 3 problem?
Not at the class certification stage. That would be addressed at a.
So we'd have to wait and see whether you could prove something other than increased shipping cost in the way of injury, and then we'd rule on standing later?
I think the defendant could raise the standing issue at any time, but it's not part of the class certification proceedings.
Well, with regard to the standing, you've got a little factual problem here because the district court found, as a matter of fact, that 32% of the all-payer class had no antitrust injury. And that factual finding, you know, I haven't seen that many class actions go forward where 32% of the class had no antitrust injury. That's a real Article 3 problem, as the Second and Eighth Circuit have found, and they've refused to certify damages classes against with uninjured members. And I'm not saying that every class member has to have suffered an injury, but 32% of a class, that's a lot. And that's a factual finding which is subject to a clearly erroneous standard. And that's what you need to overcome, a clearly erroneous standard and an Article 3 standard to get to your all-payer class. And, you know, those two combined hurdles, they're hard. See, antitrust class actions can be complicated in some ways. When you're dealing with maybe an FLSA class action or something, you have a single defendant. And so you've got a single target there. But see, the problem with antitrust class actions, and this isn't to say they can't go forward, because they can go forward, but when you're dealing with multiple defendants in a multiple defendant collusion suit, you got to be, you know, those are much more difficult to pull off. And this one just has, it just has all kinds of problems. I'm just being honest from my standpoint. I may not speak for anybody else, but there are problems here. There really are.
I've exceeded my time. May I respond?
Well, you've got some rebuttal time, but I've taken too much of your time, so you go ahead and make the point that you want to make, and we won't take a second off your rebuttal time.
Thank you, Your Honor.
And I'm sorry for taking your time, but I'm going to give you some.
The district court did find that 32% of the class was uninjured. It was not consistent with the standard that he was supposed to apply on class certification. The issue he was addressing was predominance, and that is whether there are commonalities of class members. The class members will rely on common evidence to prove injury if, in fact, the evidence they will present at trial is unpersuasive. That merits certifying the class and then entering judgment against all class members, or at least those 32%. It is not a basis for denying certification, where plaintiffs are not relying on individualized evidence for each of those 32% of the class. And that affects only the all-payer class.
Let me ask my co-panelists if they have questions. No, we don't have questions.
May it please the court, Lisa Buney with King & Spalding on behalf of defendants, and I am joined today by Fred Jorgensen, who is General Counsel of Inmar. I want to start with where your Honor's questions focused, which is on the standing, Article 3 standing issue. As Judge Quattlebaum noted, it is indeed the obligation of the court at the outset on a jurisdictional basis to make sure that there is Article 3 jurisdiction. And the Supreme Court made...
Well, it's important because you don't want to put pressure on a defendant to settle cases with uninjured members who suffered no harm. You can't, the class action dynamic has all kinds of pressures on a defendant. And a lot of those defendants, those pressures are legitimate because the class actions have a lot of benefit. But at a certain point in time, you say, no, it's not a fair pressure to put on a defendant to settle a class action where 32% of the people didn't even suffer a harm. That's not right.
I couldn't agree with you more, Your Honor. And I think addressing Article 3 standing at the class certification stage is appropriate. The Supreme Court noted in TransUnion that all class members must have Article 3 standing, which requires concrete and particularized injury. They deferred, they noted in a footnote that they were deferring as to whether the issue had to be decided at class certification.
How many defendants are there in this case?
There are 3 defendants, Your Honor.
How many?
3.
So, Counsel, you were just getting to the point I wanted to follow up on, there must be standing for all class members. Let me just, first of all, that wouldn't apply to the limited payor class. That has, you have separate arguments for that, but standing wouldn't be one of them. Is that right?
That is correct, Your Honor.
Okay. Now, as the all payor class, that all class members must be injured. Your colleague's argument is, well, we have some that don't have shipping cost increases, but that doesn't rule out that they each have some injury. And Judge Wilkinson's right. The district court found that they don't have injury. Is it that finding that makes this a standing issue now? Because it seems like if there were other injuries that could be alleged that hadn't been ruled on, then maybe class cert isn't the time to do it. But is your point that, well, generally you don't have to do it at the class cert stage under TransUnion, but when you have a list that has some without shipping cost, and B, a finding from the district court that there's others that this market damage wasn't proved, that's where it comes in?
So I think going back to TransUnion, the Supreme Court specifically declined to say, they weren't ruling on whether it had to be an issue decided at class certification. So that's an open question.
Mm-hmm.
I think that the better course, going to Judge Wilkinson's comments, is to decide it at class certification, given the interim effect that a class certification can have on defendants. And if a class member has to have Article 3 standing to be able to recover any damages at the end of the day, that might as well be a decision that is decided at the class certification stage before you have the interim.
So long as you have a record that lets you do it.
That is correct. And so here, what was before the district court, he made a specific factual finding that is not clearly erroneous, that a third of the all-payer class does not have injury. In particular, some of the testimony that he heard from Dr. Grace, plaintiff's expert, is that for those class members, we could not observe the harm, and we're not going to be able to measure that stuff. And
so on the limited payer class, as I understand it, the definition of the class was adopted just from an arbitrary cutoff. And the problem with the arbitrary cutoff is that 39% of the class, again with the district court finding, but that was based on plaintiff's own expert. And 39% of the class were excluded by the plaintiff, by the cutoff. Well, if 39% of the class are excluded by an arbitrary cutoff, just the difficulty is that class actions are not a superior way of resolving the case, because that 39% that were excluded from the class could still bring individual suit after individual suit after individual suit. And so you get into the 23B requirement about whether it's a superior way of approaching a case. Well, if 39% of people or of injured people are excluded, just with a blanket exclusion, they're still free to bring individual suits. So what's the advantage of a class action?
That is absolutely correct, Your Honor, and that was the basis that the district court rejected the limiter payer class, was both on superiority grounds under Rule 23B and also on ascertainability grounds.
Does it make, to follow up on Judge Wilkinson, I was curious about the grounds for the limited payer class. The superiority argument, I follow my colleagues' questions and your answer to that. Ascertainability is certainly a requirement that our court has adopted, but normally ascertainability relates to whether you can identify who's in and who's out. And I wonder if that, say what you want, and you may say some things about superiority with the limited payer class, but you do know who's in and who's out. May have other problems. So I wonder if superiority is not the better argument, which the district court found as well, as I recall.
Sure, I agree both arguments have their strengths. With respect to ascertainability, it's not just a matter of whether you can identify the members. It is a matter of whether the definition is defined by objective criteria, and that's in this court's Adair decision.
What's unobjective about whether you're on a list or not?
So
that may have separate problems, but what's unobjective about that, or subjective?
In the limited payer class, plaintiffs defined it as it's reference to 2.2 million coupons or 8 months of paying shipping fees. And those measures were criteria that plaintiffs defined, and other courts have held that where you have plaintiff defining the measures, that is arbitrary.
Yeah, I get that. Yep. Maybe it's just semantics. I get the part that it's not based on conduct, it's based on the plaintiff's definition, and I understand the reasoning. To me, it doesn't seem to relate to ascertainability as much as it relates to superiority.
I think you're right, Your Honor. Superiority is certainly an easier way to look at it.
Just conceptually.
Just conceptually, because superiority goes to whether it is the most fair and most efficient way to resolve the controversy. And certainly where you have, a third of the members that aren't part of the class that do have the ability to bring individual claims, subjecting defendants to a series of lawsuits.
So it's kind of nice to come before a court with multiple good arguments, isn't it?
It really is.
Counsel, could I go back to the all-payer class? If your colleague is correct, that there is that the record doesn't rule out some injury to those 32%. I understand your argument that the district court made a finding, and I appreciate that. Maybe that's enough to address standing now. But if the record is less than clear, hypothetically, predominance is still an issue. That's what the district court ruled on, correct?
Absolutely, Your Honor. And predominance actually affects, as we argue first in our brief, predominance affects all of the classes that plaintiffs have put forward.
Right.
And this goes to some comments that Judge Wilkinson made earlier about the plaintiffs that you have here of manufacturers. This is not a case where it's consumers of a product over the shelf. Your plaintiffs here are proposed manufacturers such as Nestle and PepsiCo and Coca-Cola and Johnson & Johnson, Kimberly-Clark. These are just some of the members of the manufacturers clearly able to bring a lawsuit by themselves if they thought they had been wronged. And in addition, given that they are sophisticated parties, they all had terms and conditions, or for the most part had terms and conditions under which they would pay shipping fees and process coupons that retailers took in from consumers. And it is those policies that they have on payment of shipping fees that make this a case not appropriate for class certification.
So with that said, there's discussion about this fail-safe concept. I see how that may be an issue under the definitions, particularly well, maybe both, but do we have to address that as a categorical issue here? It seems as if maybe this has some fail-safe elements, maybe the initial one with observable shipping costs is more of that, but that's really not before us. I just wonder if, because the Fourth Circuit, cited that in the EQT case, but it didn't adopt it. So I just wonder if the more traditional requirements of Rule 23 don't allow us to address the issue here as opposed to making a decision on whether we adopt this fail-safe measure or whether that is just handled by the other elements of the rule.
Sure. I do not think fail-safe needs to be determined in order to affirm the district court's holding, given the predominance argument I was making, which is under Rule 23B3, that based in the record and based on all of the manufacturers' different policies on what shipping fees they would pay, that individual issues are going to predominate over common ones, and that impacts all of the proposed manufacturer classes. So you don't need to get to the fail-safe issue to affirm the district court's denial of class certification. But I'm happy to address the fail-safe issue if the bench would like.
Well, the fail-safe issue and the Rule 23, they're sort of independent. In a way. I mean, the fail-safe issues seem to go to the appendix.
Yes, Your Honor. The fail-safe issue did go to the appendix, and this is where plaintiff was arguing with respect to the list that they just submitted a list and that should be okay. That would open up the floodgates, I think, of class litigation. If a plaintiff could just come forward with a list of proposed people in the class and have the court approve that, I really do think from a policy matter, you'd see a floodgate of class actions. It's also inconsistent with Rule 23.
Is there a case that where a class has been approved like that? Like, I got an expert and here's a list of people and they're in, as opposed to a verbal description of the class? And by asking that question, I'm not trying to suggest the plaintiff doesn't put some descriptions on it. I don't want to be unfair, but just the concept of, okay, here's my list. It seems like that list is odd because it may exclude people. In other words, we predetermined a list, and here they are, but there may be people that, even if it's described, aren't on that list, and they're not able to participate. Doesn't that create a problem?
Absolutely, Your Honor, and that's what the 10th Circuit in the Rivera decision, that's exactly what that court addressed, is that in that case, plaintiffs had submitted a bare list with no class definition.
Right.
And so, one, Rule 23 in your order on class certification requires that there be a plaintiffs have cited with respect to your question on any authority, plaintiffs have cited one case, the McKeague case, which is a district court opinion.
What district court? Within our circuit?
Give me one second.
If it's in your brief, we'll get it. Don't worry about it.
It is cited in the briefs.
Okay. All right.
With respect to that decision, plaintiffs point to the fact that a list of names was submitted. The only reason the list of names was submitted, if you read the opinion, is because the district court asked for a list of names. So both a definition and a list of names were provided, which is fine. The district court is always able to ask to see a list of names that get generated by the definition being proposed. So you can have a definition without a list, but you can't have a list without a definition, because Rule 23 requires that the class be defined, and it has to be defined by objective criteria. Are there any other questions I could answer for the court?
Would you like to guess? Judge Barner?
No.
Thank you for your time.
Mr. Lowe?
Your Honor, the three defendants in this case are all related entities. The other conspirator is not a defendant in this case. Plaintiffs did not brief to the district court the merits of injury, only the fact that plaintiffs are relying on common evidence of injury. So the record wasn't adequate for the district court to make a finding that certain class members.
So are you saying that's clearly erroneous?
Well,
the
yes.
district court's finding about injury, your position is that's clearly erroneous?
That it applied the wrong legal standard below and made a finding.
So you say it's a
injury.
legal error?
Yes, Your Honor.
What was the legal standard it applied, and what was the legal standard you think should be applied?
The standard applied was to rule on the merits of whether there's injury or not. And on class certification, the issue is whether there were, the plaintiffs will rely on common evidence and whether common evidence will predominate at trial.
But are you saying it's irrelevant for a district court to determine if it were the case? I mean, I know you claim might be injury or there is injury, but I mean, the fact that there are class members that there could be uninjured class members, are you saying that's an improper thing for a district court to consider?
The standard is whether there are class members who could not have been injured under the circumstances, not whether there was not actual injury. It's not the district court's job to determine whether class members were injured.
But your whole class hinges on Dr. Grace. I mean, you kind of made that call, and that may have been a good call. please don't take this as a criticism at all. But when you make your class dependent on something that your expert has put together, doesn't testimony from your expert that we're not going to be able to determine that issue come with the bad that comes with the good?
There's other evidence that plaintiffs present that class members are injured, so we're not relying solely on Dr. Grace.
All right.
But that is the basis for the fixed list class, but not the other two class definitions. Her testimony.
On the limited payer class, can you explain the cutoffs and why they make sense?
Those were based on Dr. Grace's professional judgment as where the natural breaking point was, where most people who had more purchases than that were injured. And those were people who had more exposure to the conspiracy than people who had fewer purchases. It's similar to the Boggs case, where there was a 6-mile radius around radioactive activity. There has to be some cutoff. There's no objective way to choose the cutoff. So it has to be subjectively chosen, and here it was based on professional judgment.
So there's a time element to it, and then there's a number element, right? And in order to be a part of the limited payer class, the manufacturer has to meet both, the time and the number.
Correct.
And so is then it correct to say that the limited, I'm trying to think of this visually, that there's all of the manufacturers, and then a subset of that is the limited payer class?
Correct.
Does the limited payer class necessarily exclude the alleged 32% non-injured parties, or is it a Venn diagram where there's some included and some excluded, and we don't really know whether there's any relationship between the 8-month cutoff and the numeric cutoff and the non-injured, allegedly non-injured manufacturers?
It is a Venn diagram, and there's a specific number of manufacturers identified who are not identified in Appendix A of Dr. Grace's report as being injured.
But we don't really know the exact number, right? Because this isn't a fixed list class. It's a class based on a definition, which is exactly what we were talking about. The difference between a list and a definitional class, a definition of a class. And what you're saying is, it's not actually, to counter your colleague, you're saying it's not actually arbitrary, this cutoff. It's a natural breaking point. And so it's not that we just picked a number out of the hat, 8 months, several thousand claims. We're saying, no, this is based on expert testimony, this is the natural cutoff, and that's why the limited payer class makes sense, and is, in fact, does meet all of the various tests, ascertainability, and it is the preferable class. Is that right?
Correct. It is definitional, but using that definition, you can make objective determinations, and Dr. Grace did make those objective determinations of who paid for more than 2.2 million coupons, who is made purchases during 8 months or more, and has identified those numbers and specific class members. Just as for the fixed list class, the definition is those who Dr. Grace determined that based on a specific regression analysis, paid higher prices during the conspiracy period than before. That is how that's defined, and she carried out that analysis and identified those class members as well.
But if we were to find that the district court erred in declining to certify the limited payer class, we wouldn't have to reach the fixed list class. Isn't that right? That
That's correct.
It's sort of a one or the other thing. And
Yeah,
I'm assuming there, too, it's a Venn diagram.
Correct. Any one of the three could be certified.
Well, the all-payer class includes everybody, right?
Correct.
So it's just the whole group. And the other two are subsets, which what you're saying is they overlap.
Correct, they overlap. But I'm saying, if the court certified any one of the three classes, then it wouldn't have to reach the other two.
I have one more question. I have a question about the limited payer class. I appreciate the argument and that Dr. Grace said this was a natural breaking point. Is it correct that breaking point, it seems like there's two ways it falls? I mean, it seems the justification would be the more you engage with these processors, the more likely you are to be injured. Is that kind of the logic about it?
Yeah, correct. And also, if you were there for more than 9 months, it indicates you weren't able to substitute away to an alternative process.
The other thing that seems to flow from it is that if you were a victim of the alleged conspiracy and it only happened to you once or twice and you have a very small claim, you're excluded from the class. Is that correct?
Well, you'd have less exposure and a smaller claim. There's also a greater chance that you would not have suffered an observable harm.
Yeah, but that's just odds, right? I mean, the more you do it, the more likely you are to have been injured. But my concern is one of the reasons for class actions often is the least injured plaintiffs may lack the incentive to actually, pursue their own individual claim. And it seems your class excludes the people who would be most benefited by a class action.
Well, I think in this case, all of the class members it wouldn't be economically feasible for any of the class members to bring individual claims because of the cost of bringing an antitrust class action. And the ones with larger claims are the ones who will benefit the most because they have the most at stake.
God, that just seems, that last point you made, maybe I'm missing something. That seems backwards to me. It seems like a lot of the reasons we have class are very individual. In the consumer context are people who have very minor claims who would never hire a lawyer and bring them on their own. And it seems in your effort to avoid uninjured classes, you've excluded the people of the class members who would most be in need of this.
Well, we've proposed alternative classes in which our first proposed class would include everyone who suffered observable harm.
But that's not, we already discussed that. That's not on appeal.
For the limited payer class, well, that is on appeal. That's we've been through that. But for the limited payer class, we're trying to define a class in order to benefit the most people possible. There is not under inclusivity criteria to class certification, as the Third Circuit recognized in Byrd versus Ahrens, requiring the plaintiff to represent all potential plaintiffs creates problems. To the named plaintiff. And so there should not be an under inclusivity criteria to class certification.
Thank you.
Thank you, Your Honor.
We thank you, sir. We will, Judge Bernard, did you have any?
No.
Okay. We will adjourn court and come down and greet counsel.
This honorable court stands adjourned until tomorrow morning. God save the United States and this honorable court.